today's talk is on which are the laws which empower us activists. Over here we all, as you very well know, we all struggle to get either our issues with the government redressed, or we strive for good governance, or try to curb corruption, get better, prevent them from abusing their power. In whichever way possible, we try. Each and everyone, I believe, we do that in our own way, facing all the troubles that comes along, part of the game. So, for that, as you must have read in our invite, we have invited Senior Advocate Gayatri Singh over here to address us, to explain to us, which are the laws which empower, how we can, use it for the well-being of the nation, for better implementation of laws, and to curb corruption and get better governance, abuse of power and everything. So we have invited her. I would like her to, take the chair over here, if you don't mind. Advocate Gayatri Singh, please give a clap.
Hi everyone.
Welcome, Advocate Gayatri ji. It's a pleasure to have you over here. And we keep reading about you in the newspapers and everywhere. But today is the first time we get an opportunity to listen from you, hear you, and guide us in our activism. Before I proceed, I would like to give the little background about Advocate Gayatri ji. She has been practicing law since 1984, and she has been designated as a senior counsel in the year 2015. And she has been taking up cases of displacement of land issues, bovine grazing lands, Gairan lands being, de-reserved, and construction and all those things, removal from this thing, those people from there, the original people from their bovine grazing lands. And about Dalits, Dalits' rights, she has fought a lot of cases in the courts. By the way, she's in the Bombay High Court and Supreme Court. Both she, goes to fight the cases in the larger interest of everyone. And laborers' issues, laborers' rights, housing rights.
Louder.
Loud. Okay, sorry. Okay. Then women's rights she has been fighting for also. She has been associated with the prominent NGOs you all must have heard, PUCL, People's Union for Civil Liberties, and another one is WPC. What's the full form of that?
Workers' Coalition. It's a
Workers Coalition. Then she is involved in cases involving informal and migrant workers' rights. During COVID, you must have realized those informal sector of workers, they were most were affected a lot due to the COVID sudden appearance of this pandemic. So for their rights, she has been migrant workers who go to other states for their roti, and she is involved with various workers organizations, laborers organizations, and human rights issues. The list goes on and on. These are the main points which we have selected. So that's how it is. So welcome, Advocate Gayatri ji. Now Gayatri ji, I would like to tell you all about the group. Majority of other people over here are interlinked in some way or the other. The group which has convened this meeting is Petition group, as we must have told you. They are a group of dedicated activists. They have filed their own cases, as each and everyone over here have faced, are struggling for good governance, redressing their grievances. That's a mix of everything. Like they have their backyard problems, but then they know that bad things are going on in the government, so they, in their own way, use the laws possible, like RTI Act, or Delayed Discharge of Duties Act, or Service Conduct Rules, and there are several other things which can be used. Service rules, there's one Service Act also. So in their own way, they use these to make them accountable, get transparency and accountability. So that's what we all try. We all network on a WhatsApp group. On and off, we hold such educative seminars over here, and few of them over here I would like to introduce. I mean, it will be difficult to introduce each and everyone over here, but few of them I would like to bring to your notice. First one, of course, our Bhishma Pitama, Mr. KVJ Rao. Criminal law, though you may ask for his LLB, he doesn't have LLB. And his chela next to him, Swarup Kulkarni, Advocate Swarup Kulkarni. All three Maharathis are sitting in line. Sanjay Kurhade, there, heavyweight, Sanjay Kurhade. So, and of course, I can't forget him, of course, Kamlakar Sharma, which you know very well. Kamlakar ji, our firebrand leader, Kamlakar ji, and the couple over here, Shivnarayan Sharma and Soni Kalpara, she must have heard of them. And all our struggles, they are there. Police station, maybe police station, maybe court, maybe authorities, they are with us fighting, so and supporting us in whichever way possible. There are many such over here. It's not, these are our main Navratnas of our group. Gayatriji, once you give the talk, and keep about half an hour, 45 minutes for question answer, because everyone is loaded with questions.
Yes.
Let's understand
It
this.
has to be.
Everyone has queries. So can you make a note of those, points which you wish to ask on the way? In between, avoid interfering because that link will be broken. So kindly avoid it. Okay. Our member Kamlakar ji would like to say a few words. Come, Kamlakar ji.
It's a great honor for us that Madam Gayatri Singh is here. We have known her very well. She has been a great pillar to people like us, especially an activist. In this meeting, I would request Madam, that we have certain basic problems with the government law making procedures. One is the 17A of PC Act. 17A of PC Act, we need to challenge it, that is what I feel. Because it basically destroys section 154, 157 of CRPC and the basic element of CRPC because of 17A. And it promotes destruction of evidence as well as disappearance of evidence and influencing the witness. So 17A is a great hindrance for us to prosecute the public servant. And the anti-corruption has become absolutely not working. In the last 5 years, they have registered only 5 cases. So that shows that Anti-Corruption Bureau is coming to an end. Then there is another thing, High Power Committee. The investigating agencies are forwarding each and every complaint which is disclosing cognizable offence to some agencies, High Power Committee or police, or SRA, ADA, and what they do is they just keep it pending. My recent experience, yesterday I received an order from High Power Committee. My complaint is 2018. My hearing was held on 11/8/2023. All were present at that point of time, and I challenged their authority to conduct such meetings. I did not argue on the question of merit, but yesterday I got an order that our matter is dismissed. But without going to the merits, and I am challenging the jurisdiction, so there is no question of jurisdiction, and they have come. So we need to challenge such basic things which prevents a common man from prosecuting the public servant. The other thing is there is an amendment under 153 and 190 where a police can register an FIR, but the court cannot direct to register an FIR, which is absolutely very unfortunate on our part. That if a police can register an FIR, why can't a court direct registration of FIR? And the third thing is there is a regular change in attitude of the government as well as the public servants, that they pass illegal circulars which is contradictory to law. And we have got two options, either to prosecute them or to challenge them in the writ. So challenging them in a writ and then going for prosecution becomes very difficult. So please let us know that passing an illegal circular with full knowledge that it is contrary to law, there should be some shortcuts where we can prosecute such officers, because वो circular pass करेगा 10 साल जाएगा तब तक सब हजारों करोड़ का नुकसान हो चुका होता है. This is what अजय मेहता के बारे में मेरा कंप्लेंट मजिस्ट्रेट कोर्ट में है, and we are arguing from that point. So these are the basic things which are promoting the corrupt public servants recently. In last 10 years, we have seen that the law is such which promotes corruption rather than stopping corruption. So we wish that you will give us a good knowledge and information on these facts and how to fight on it. Because we are all fighters over here, we want to create a basic foundation for our next generation. If today we are unable to give a good sound foundation for the next generation to fight against corruption, this is the end of the nation. That is why I request you to please guide us, and thank you so much for listening.
Advocate Gayatri ji, kindly accept a little bouquet of welcome. Okay, Advocate Gayatri ji, I give the mic to you.
I'm sorry for this introduction because you would like to hear ma'am. All of you have come with so much of enthusiasm and you have been all struggling just like me. And sir said, we are not fighters, we are not fighters. As I said earlier, they named us fighters because we are telling them what is the law, so they said we are fighters. We aren't fighters, we are very, very calm, very, very patient. I think each one of us is more patient than an ordinary citizen. And of course, we have great people in our groups like Garanji and Rao sir and all the others. I don't remember all their names. And of course, we have people like Advocate Madam to support us. So I think they are doing a great job. We are only being with them. We are not doing anything much. So as a token of our appreciation from all of you, we will kindly accept this.
She is the firebrand leader from Chembur. Mrs. Vasanta Sena Srinivasan. Thank you very much, madam, for the support for pension group people. Thank you very much. I forgot to mention, welcome everyone. I think there are budding advocates over here and law students, and welcome our reporter from Free Press Journal. Where is he? Mr. Dhairya? There he is. Thank you. Welcome. So welcome everyone. Okay. And now I hand over the mic to Advocate Gayatri ji. Thank you. You can use anyone. Yes.
So I will try not to make it too legalistic because I'm sure there are many people here who are not lawyers and nobody wants to hear a long drawn out speech on law, which is very boring. Even we lawyers get bored with it. So I will try to make it as simple and also as practical, that how it can help us and how it doesn't help us a lot. And I would like it if it's a more interactive session instead of just someone lecturing. So I will try to be very brief and we can spend more time in questions and answers, which will be helpful. So I would really like to start off with our right to file an FIR, which everybody knows what our right under the IBC is and how an FIR can be filed. But basically, I'd just like to emphasize, because it is here that we find the major problem. And if there is any cognizable offence, okay, so it has to be a cognizable offence. And those cognizable offences, I don't have to go into it right now, they are all listed in the IBC. So you have for 2 years, 3 years, 7 years, all the punishments are listed under the various sections, and then it becomes either cognizable or non-cognizable. I think this basic thing everybody knows. It is only a cognizable offence that can be registered as an FIR. So if we say, for example, I'll give you, there's so many examples, everybody has had experiences in their private lives as well as public. For example, we're doing some cases of tribals who are being evicted from RA colony. Everybody knows there was a big struggle in RA also. And there are, because of the metro project coming up, or different projects coming up in that area, people are being evicted. Most of those people who are being evicted are the tribals in that area. And there is a Film City, as everybody knows, Film City, which is actually a government company, has been slowly encroaching upon the tribal land and taking over land which belongs to tribals. tribals who've been cultivating the land for many, many years. I'm just giving you one blatant example. There are so many other examples. So here, the Film City people started encroaching into the land where they were cultivating. People protested. Nobody listened to them because these are all important high government officials. And the police also was supporting them. So when complaints were made by the tribals that this is an illegal, people are illegally encroaching upon our land, and that there were many instances where their houses were broken, their crops were destroyed, and that those provisions or those offences come squarely under the SC/ST Atrocity Act. Everybody knows about SC/ST. So that act very clearly says that if any tribal land is encroached upon or possession of land is illegally taken by non-tribals, then it becomes an offence under the SC/ST Act, and that is a cognizable offence, which has to be registered immediately as soon as someone comes, a tribal comes to make a complaint. In this case, several complaints were made, nothing was done. The police also would call them, then make them sit there for many hours and then tell them to leave. And in fact, they, along with the police help, along with the, Film City people, they would help the Film City people to enter their houses illegally. Now, after several months went by, people were not registering it. Finally, ultimately, what is the recourse that ordinary people can take? That is, go to High Court or go to the Magistrate Court. So finally, we decided not to go directly to the Magistrate Court. I'll just tell you the provision also, where you can go to the Magistrate Court also. But we decided to go to the High Court, and there the High Court has directed them to record their statement and then register the FIR. So question is this, that under section 154 of the IPC Act, it basically says that if a cognizable offence is reported, and you can orally report it, it's not necessary that you have to give it in writing. You can orally go and say, and even a person who is not affected can go and say that this such an offence has been committed, a cognizable offence, but you have to make out a case. You can't just give a vague statement. So under 154, that is a provision which says that if a cognizable offence is made out, then the offence has to be registered. 1 second. I'm looking at the IPC instead of the CRPC. So I don't want to read out that provision, but I want to point out how important this is. So this is called information in cognizable offence, and a cognizable offence has to be, FIR has to be registered. Now, there have been number of cases which set out under what conditions it must be registered. So there was many Supreme Court cases which said that a police officer need not immediately register a case. He or she must investigate, and then after investigation is done, then it must be registered. But subsequently, in a case of Lalita, everybody knows about Lalita's case, where the court said, no, you have to immediately register a case if a cognizable offence is made out. And that law is not being followed by the police stations at all. So one is that we must be very firm that an FIR has to be registered if a cognizable offence is made out. Two, a copy of the FIR has to be given. In many cases, I don't know how many of you have tried to register the case, but in many cases, FIRs are just not submitted, are given to the complainant. And that is how people only subsequently get to know that, oh, these are the provisions which have been included in the FIR, and so provision is not correct, or the actual provision has not been added. You only get to know after you get the FIR. So the second most important thing is that we must get a copy of the FIR, and it has to be signed by the complainant, so that the complainant knows what is the section, what is provided under that. Now, this is the law as it exists. After the FIR is filed, then an investigation is done by the police. And investigation is done and a arrest warrant can be issued even without a warrant being issued by the magistrate. So it is not necessary that a magistrate has to issue a warrant. Even if a police investigation has been done, the person can be arrested immediately if it is a cognizable offence. So this is the third part that we must remember as far as the arrest of people are concerned. Now, this report, whatever investigation he or she does, has to be submitted to the magistrate. It is upon the submission of the report, which is called the investigation report, that a charge sheet is framed. So this is basically engendered in very simplistic, the procedure, I've just set it out. What happens in a case where majority of our cases are cognizable offences, non-cognizable offences, so which are not of such a serious nature, but there are also serious. For example, a person can repeatedly keep threatening you that I will kill you, or say something against your religion or whatever it is, which might not be a cognizable offence, but the threat itself can exacerbate to a level where it will become a cognizable offence. Right? So it is very necessary that we have evidence to show that this was the process by which that particular person threatened me, and finally now the threat is almost going to be implemented. So the non-cognizable complaint also has to be recorded, and that has to be recorded by the police officer in his diary. Right? So once that is recorded, then you have some evidence, and once say for example, today you make a complaint, again that person after 2 days threatens you, then you again go and make a complaint. So therefore, it is important to keep on building up on your complaints, so that you have a case made out that there were these constant threats against your life, or against your property, or against your family members. This is also, though we might think that, oh, why should I go and waste my time making a complaint, but these are all important points which will help us later in filing, if at all necessary, filing an FIR. So in such a case also, the police is not required to conduct an inquiry in a non-cognizable offence, and therefore you have to make a complaint if nothing is done to the magistrate, and you can file a complaint saying that this was not done, whatever ABC investigation was not done, and that complaint can be filed before the magistrate. So even in non-cognizable offences, you have a right to approach the magistrate. Now what happens where you go and the police does not register an FIR, like the example I gave you about the tribals, it did not. So there are three options. One is that you make a complaint to the superintendent of police about that particular police officer. So you say that so and so on so and so date you came, you made a complaint, it was not registered, etc., and you make that complaint to the superintendent of police. Now the superintendent of police is not supposed to just sit on it. He or she has to personally investigate or delegate that responsibility to some other person. So that investigation into why the FIR was not registered has to be done. Yeah. So that part is very important in terms of making that fair. So we should not just give up and say, oh, I went there twice, thrice to the police station, they have not registered an FIR. Then we must follow up with a complaint to the superintendent of police. Now I'll give you one example of that. For example, there have been a lot of issues relating to hate speeches that are going on. And in Meera Road, everybody knows that there was this big rally, and also the person I will not name, but the person who came and gave a speech in the police station. So he makes a speech inside the conference room of the police station, saying that ABC members, whatever, the Muslim community are going to be beaten up, they will be thrown out, they belong to Pakistan, etc. All those statements were made and actually recorded. Okay, now we have separate sections on hate speech. For example, you cannot make a speech. I can say something against, say, one person, that this person is a idiot. Okay, or that he is going to murder someone. But my speech should also have an effect on actual violence being done. So my speech has some linkage with the violence that is subsequently committed. So suppose, for example, in this particular case, the MLA made a statement saying that Muslims are creating a law and order situation, that they should not be allowed to reside in that premises, they should be thrown out, and their houses should be demolished, and etc. etc. All these speeches were made. Now, by itself, fine, someone can say, no, how can a cognizable offence be registered, FIR registered against this person? He has his own personal grievances or personal prejudices, etc. How can you just file a case against him? But his very speech led to the violence against the Muslim community. It led to the demolition of the masjid that was there, and also it led to the demolition of various houses in that area, shops which were there. Whether they are legal or legal, it's not for individuals to decide, right? It is the government. If suppose the municipality finds my house is illegal, then they will give me notice, follow the law, and accordingly take a decision on demolishing it. Individuals cannot come and demolish my house just because they think it is illegal. So because of the speech, actual violence took place, where Muslims were attacked, their properties were attacked, the masjid was attacked, and people were injured in those incidents. Now, in such a case, is not the police required to register a complaint? Because in this particular case on hate speeches, as everyone knows, there are petitions filed in the Supreme Court, and the Supreme Court has issued directions saying that in any case where a hate speech is made, FIR has to be immediately registered. So here not only do we have the law on our side as far as registration is concerned, but Supreme Court has also passed orders. And so therefore, if you are not complying with the law, that is the police officers are not complying by registering an offence, then it is not only a violation of the law, but it is also contempt of Supreme Court order. Correct? Now, if such is the case, then is it not the responsibility of the police officer or whoever is in charge of that police station to immediately register a complaint? So many people registered complaints, both in writing and orally, saying that please register a complaint against ABC person. The police, commissioner of police of that area, as well as the deputy commissioner of police, complaints were made. They just played a totally blind eye to the entire issue. The people who are registering complaints, action is being taken against them. So the funniest, I mean, it's not funny because it's a sad situation that people now, suppose I am not personally involved in that incident, correct? I am not the person whose house has been demolished, but those people whose houses are demolished or who are being injured or who have been attacked, they are too scared to come forward and make a complaint. So in such a case, is it necessary that an individual whose house who's been personally affected should come and make a complaint? It's not necessary. If a person who has seen the incident or who is aware of the incident makes a complaint, and that is what I was trying to tell you as far as FIRs are concerned. Any person can lodge it, but it must be very specific and under those particular sections it cannot be vague. So again, the power of the police station or the police officers to register a complaint under FIR again is ignored in such cases. So here, what should we do? What should a citizen do? For example, in this particular case, those people approached me and said, what should we do? Because people who are affected are not willing to come forward. So I told them that if the police officer is not registering your complaint, then make a written complaint to the superintendent of police. That is the first step that we should take. Even then the superintendent of police has refused to intervene in the matter. So then what should be done? Then the only alternative is either to file a complaint under 150, or it is actually 154.3, where section 154.3 of the CRPC, where you can file a complaint before the magistrate. Now, as we all know that if we go before the magistrate, a lot of time is taken and we might go on struggling for many years before any notice is taken of a complaint. So therefore, in most cases, we go either to the High Court or we go to the Supreme Court. In this particular case, as Supreme Court, people have filed a contempt in the Supreme Court against all these officers. But that is just, I'm just giving one example of the seriousness of the issue where FIRs are not being filed. Even in cases where houses are demolished of individuals, complaints are not taken on record, etc., etc. So this is as far as the FIRs and registration of complaints is concerned. So one is we make a complaint to this thing. Second is to file a individual complaint, and the third one is of course to go either to the High Court or the Supreme Court. Now I just want to emphasize one more thing about the problems that we face when we register an FIR, say against a police officer or against a government official. What are the problems that people face? I would like to ask you a question. But can someone tell me, like, what are the when you file an FIR, once you cross that hurdle of filing an FIR, what is the problem that we face? Maybe if people can answer that, then I'll come to 197.
Sanction.
Let's not go into sanction. But other problems. Sanction is the most important, of course. But any other problem?
You're dissuaded from going ahead.
Yeah.
They will file wrong cases on you. They'll call you to the police station, keep you sitting there. Then they'll ask your neighbors to file false complaint against you, or shopkeepers below to file, or your committee members or of the chawl or housing society call you every time. Then they'll pick up issues against you. They'll go searching for evidence against you.
Yeah, so in this particular case, the person who wanted to file an FIR said exactly that when I went to the police station, they created a situation where they created a false record about why I had come. So they just made up a thing that she came and abused someone, or she attacked someone, or she threatened some officer, etc., etc. And that provision is there, I think, in your note which you circulated about what are the 218 and 219. All these are sections which deal with an officer, police officer or public servant creating a false record against you. Okay, so they can either create a false record or they can create a situation where they implicate you in some offense which you might not have committed. So the best thing to do in such cases is, if you are going to the police station, you must record everything. Of course, when you start recording, the police will come and take away your mobile or they will say that you are not supposed to record. But make sure that you do it in such a way that it is recorded and something is given in writing to say why you went and for what purpose you went there. So there is something on record, some record is maintained as to why you went to that place. I mean, that's the only way in which you can try to get away from false implication or false records being created. But I would like to, main problem that we face is really 197, the section 197 of the CRPC. And I just want to, I don't want to read the whole thing, but for people who are not aware of 197, I'd like to point out that yeah. So what happens when you file a complaint against a police officer? Let's go by the police officer's complaint, and you file a complaint, and then subsequently the issue that is raised in the court or even before that, that the person, whatever complaint that you have made, that action actually was taken in the course of his discharge of duty. Right. So he actually did this not to harm you or anything, but to protect himself from whatever that you were actually trying to harm him while he was trying to discharge his duty. Now, I'll just give you the absurdity of this section is this, that in the discharge of my duty, that is in discharge of the police officer's duty, what does it mean? Many courts have decided, some courts have said, okay, discharge of duty doesn't mean that you go and commit murder or you kill someone or you destroy his or her property, etc. So there have been cases of encounter deaths, there have been cases of people being killed or murdered or tortured inside police custody, there have been cases of people being basically like in cases of Punjab or wherever there have been mass murders being carried out. So in such cases, most of these cases, it's very shocking to hear this, the courts have said that, say for example in one particular case of Punjab, there were many people who were killed, whatever, by so-called terrorists, etc. Subsequently, they would identify who these people are, who these so-called terrorists are, and a large number of people were killed by the police. So the question arose that did that killing, was it absolutely necessary to kill that person? Because after all, the police were only carrying out their duty, is trying to. So the courts have said that when a police officer, we don't know what happened. Why did he or the police officers kill so many people? We don't know what happened. But the basic fact remains that he was performing his duty to safeguard ABCD people. And in the process, maybe he killed someone. So therefore, it is part of your duty, which is that entire incident of killing someone is really closely connected with the discharge of his duties. And that is why sanction of the appropriate authority or government has to be taken before any case is filed. So even in cases of custodial death, you must have heard of Yunus's case. Yunus was an engineer who was tortured inside the police station, and he died. And the police said that he died because he was trying to run away, and therefore he had to be stopped, and therefore he died. So question was, those police officers, complaint was filed against those police officers for murder. Question was, is it murder? Can they be prosecuted without sanction of the court? And the court said no, they cannot be prosecuted without sanction, and therefore sanction has to be obtained. So therefore that case has been going on for the last 15 to 20 years, because the government at first refused to give sanction, then finally there was a lot of pressure, and then finally after many 10-15 years sanction was given, and only after that the entire case proceeded. So the courts have really narrowed down the definition and said that it must be in the context of discharge of duties. So say for example, another example where a person is arrested for no fault of his, or is put in a lockup for more than 24 hours, and then he is tortured so brutally that he dies inside. There, in that case, the court said that it is not discharge of duty. It is because there was no section or there was no offense that person committed, and that he should have been put inside the prison. Without any section being imposed on him, without any offense being committed against him, he was locked up for 24 hours, and then he was tortured. Therefore, this is not in discharge of duty, and therefore sanction was not given, and the case was proceeded with without a sanction. So they are very conflicting judgments, but most of them are to support the police officer and the government officials, whoever has done something which is illegal, but if it is connected with his or her duty. So am I clear on this point that about the discharge of duties? It's a little complicated because there are so many conflicting judgments, but most of them actually go against us as far as the offense of the police officer or government official is concerned. Yeah.
What about a police officer creating a false evidence in the course of investigation, or not investigating the proper points which have been submitted?
Yeah, so then we come to the second point. So say for example, a case is registered and case is filed against and we proceed before the magistrate. Case goes on for 5-6 years, and then finally the police officer realizes, oh my God, their sanction has not been given. I have a right to sanction, and therefore he makes the application before the court that sanction is not given, and he makes an application to the appropriate government, whoever the appropriate government is, and the government sits on that application for many years, till then no proceedings can go on before the magistrate till a decision is taken by the appropriate government. So the second problem is that the appropriate government sits on the file for many years, does not take any action, and the case which is supposed to have, which has almost half completed, lies in limbo, nothing is done, it hangs in the air, and finally they have to wait till a decision is taken by the government. Now if the government says, okay, we have not given sanction, no proceedings can go on, then the entire case is dismissed and the accused is discharged. So you can imagine the seriousness of the issue, that in such serious offences where cases are made out against the police officers or against government officials, the case is again, if sanction is not given, then the case becomes almost like null and void.
Madam, there's a loophole. What they're saying, government officer, government official, but if you put over there government department, then the loophole is, then the proceedings goes on. You say I put a case against the government department,
Yes,
not
so
of.
yeah, okay. So now the question is, the fourth issue. So one is that the third issue was that you make the application is made for sanction, government does not give sanction and sits on it and finally gives it, then your case is totally stalled at that stage and the accused are discharged. The next point is that one, who is a public servant, and two is who is the appropriate government. These are two important points we must remember. So basically a public servant is defined under the code, and it says basically, I mean originally we thought that it is only state government and central government, right? So any person who is appointed by the state government or appointed by a central government, and if the state or central government has the power to remove that person. So suppose the state government appoints me as an officer of any particular department, but someone else has the power to terminate me, some private party has, then there is no question of sanction because it is not the removing authority. But so therefore the state government must be the appointing authority as well as the authority that removes me from service. That's most important. And the second part is, how do you define a public servant? Now public servant in the code is very narrowly defined. When we come to the Corruption Act, it is very broad. So in this case, it will be the state government, central government, it will be even the local authority. So therefore, if you are making an case against the BMC officers or officials, then they become a public servant. So municipal commissioner is a public servant. So therefore, this 197 will apply even to municipal commissioners, municipal officers who are public servants and who are employed by the local authority. So it's in a sense, it's not only restricted to police officers but also to government officers, government employees and local authority employees, as well as various other, which we need not go into right now, various other officers. But in the Prevention of Corruption Act, it is much broader. So if any company which is registered as a company under the Companies Act, even then an officer would be liable to be prosecuted under the Prevention of Corruption Act, not under 197. So you got the distinction between the two. The prevention is much broader. It includes many other officers, even including companies, officers of the companies, but must be registered under the Companies Act. It also includes colleges and universities which might be affiliated to the university. So those officers are also liable to be punished under the Prevention of Corruption Act, but not under 197. So in the
filing of e-filing of FIRs or complaints, are they cognizable? I mean, are they legal?
Yes.
Instead of going to the police station, I do a e-filing.
Yes, it is.
Is it legal?
Yes.
Or maybe there are telephone numbers of senior inspectors.
No,
or that
those are not legal.
Emails. So
You cannot make a telephone call.
WhatsApp communication and email communication, are there, this communication, are they legal?
they are legal as long as it contains the basic provisions of law. Yeah. But you cannot just make a telephone call, because those telephone calls are still today at least not recognized for registering an FIR. But e-filing only if you are able to set out the guidelines, what is the NSR. So coming,
Madam, under the Consumer Act, you can 340 CRPC is a deemed criminal court also. Without 197, you can take them to the consumer under Consumer
of course,
Act. Yes.
I'm not dealing with other alternatives that are available. I'm just saying, if we go for criminal cases, then these are the problems. Now, so therefore, that's another problem that we face with regard to the process of going on with a complaint against an officer under section 197. Now, someone had a question on 197. I think I forgot to answer that. I don't know what the question was. Someone at the back. No. So basically, the issue of how to proceed with a complaint against an officer, we have a lot of hurdles to cross before we can, yeah.
A common man finds it difficult to know who is the sanctioning authority. And under the provision of Regulation 9 subsection 2 of the Delay in Discharge of Duty Act, it is mandatory on the part of the public office to prepare that records which is known to the common man. So how should we get this implemented so that every public, especially in case of IAS officers, you do not know which is the appointing authority, where you should file a complaint. And
so in response to that, then we have the Right to Information Act. So under the Right to Information Act, even if they are supposed, under law, they are supposed to put everything on the website, who are the officers concerned from each department, who is in charge, etc., etc. All those details, even the appointing authority has to be put on the website of that particular department. If it is not done, then you have a right to go under the Right to Information, and all of you know how to approach under Right to Information, because you have to have, for each department, the PIO has to be appointed. And if the PIO is not appointed, you will not be able to make a complaint to the officer concerned, because there is no PIO. So it is the PIO who has to give the information. The RTI also has a provision which says that all details about the officer's concern has to be on the website. So details relating to the department also have to be on the website as per the RTI Act. So it's not something that is to be kept hidden and secret as far as these provisions are concerned. Now coming just very quickly, because I think I have another like 10-15 minutes, I just cover two very, very important issues on the this Corruption Act, Prevention of Corruption Act. So what basically happened was that this 1988 Act was actually introduced in 1947, which is pursuant to a commitment that India had made to the United Nations. So India is a signatory to a resolution under the United Nations known as the Prevention of Corruption resolution. So there is a United Nations resolution. I will not go into that resolution because it's very, very detailed about how in public offices corruption should be prevented. Now, pursuant to our commitment to the United Nations, we enacted this act way back in 1947, which finally was amended in 1988. Now here, actually, as I said, the definition of public servant is very broad. It includes large number of other departments, not necessarily government and local authorities. And then it goes into the definition of what a offence under this act is. So there are two aspects to the act. One, which we all are familiar with, taking bribery, taking bribes for some action that the officer has promised to do, which might not be in his normal duties, but he will do it in return for some bribe, right? So that definition, I'm not going to read it, it's a very, very convoluted definition, but basically taking a bribe. Like say for example, and these are all in our day-to-day problems we face. For example, I go to the BMC to or whoever that department is to get my ration card. To get the ration card, the officer concerned says, I will give you the ration card, but you must pay me 5,000 rupees for getting it. And therefore I pay him 5,000. Now that is called bribery. So something that I am doing to get something in return, which is actually a dishonest job on part of the officer, is known as corrupt action on under the Act. The second is to get some benefit. Say for example, I have made an application for a license to the relevant department, and that licensing authority under the BMC has a provision which says that licenses will be issued only to A, B, C, D people, and to people who conform with A, B, C, D conditions. Now I do not comply with either of those conditions, right? But the officer says, okay, I'll put you in category A or I'll put you in category B if you give me something in return. So that is putting some person at an advantageous position which he had no authority to do. That is another section which is included in this. So it's not only monetary gratification, it is also something that the officer might benefit from if he or she does some work. So there are these three broad definitions, and these are the two broad definitions. And the third is criminal misconduct. So this is a very, we face it in our daily life. The criminal misconduct is read like this. A public servant is said to commit the offence of criminal misconduct if he dishonestly or fraudulently misappropriates or otherwise converts for his own use any property entrusted to him. So say for example, I was driving a car. That car was actually, is not in my name, it is in the name of someone else. And a case is registered by the police officer saying that this car has been lost or been stolen, and they find this car standing somewhere on the road. Now, actually that would come as a criminal offence because a criminal case is lodged against me for driving a car which has been stolen, right? But suppose if the police officer comes and says that, okay, this property doesn't belong to you, or even if it belongs to me, I will take that property and use it for my own use, which happened in one case where a motorcycle was being driven by one person, and it was found that this was a stolen motorcycle, and the police officer comes and takes the motorcycle, and then the motorcycle is taken in his custody, and he has taken over the motorcycle totally. So this is criminal misconduct under the Prevention of Corruption Act. Now these three important ones, there are many others, I don't want to bore everyone with that. But these three, again there is a provision under the prevention of, I don't know how many people have gone under this act or filed cases against public servants. But again there is a provision which is similar to 197. Here also it says that if you are doing some duty or performing some duty in discharge, performing some job or work in discharge of your duty, then you cannot be prosecuted. So again we have a similar provision of 197 in this, which prevents any action from being taken. So you will find, as someone said, I think someone said that hardly any cases are filed under the prevention because of this problem. So really you are supposed to abide by the UN Convention. Actually you have made provisions in the Act which prevent citizens from making use of the Act. And then we finally have the Lokpal Act. Anyone knows about how the procedure under the Lokpal is, because it came into existence in 2013. Now during the interregnum period, that is from the time when this act was made, till the time when Lokpal Act was made, there were many cases of corruption, of senior officers, of government officials, of higher officials, etc. But no action was really being taken, or no inquiry or investigation was being made. So there was a judgment of which everyone should read. There was a judgment in 1998 known as Vineet Narayan versus Union of India. I don't know how many lawyers are here who know about this judgment, but I'm sure everybody knows, because this is a very important judgment which deals with the Hawala cases, where basically a person was arrested and then later on it was found that he had connections with senior government officials who belong to a ruling party, etc., etc., and lot of money was being exchanged through the Hawala system, and what is known as and then the police discovered, because of this case, that there were what is known as the Jain diaries, and in those diaries all details about who had accepted money, how much of money was being paid to them, at what time, all those details were set out in the Jain diaries. Now despite these details being furnished, no action was taken by the police officers and no investigation was carried out. So therefore, some people filed this case, and the Supreme Court did what it is known as a continuous mandamus. That is to say that it is not just one order that a Supreme Court passes, but the Supreme Court actually supervised the entire investigation of that case by passing continuous orders, till finally some action was taken and charge sheets were filed against the concerned parties. And in the process they set down certain guidelines. So one most important part was regarding the enforcement agencies. That is to say, everybody knows the CBI, then the Enforcement Directorate, and then you have the RAW wing, which is basically the investigative bodies of the central government. Now the CBI in this particular case, even though it was a central government body, it had to carry out investigation, no investigation was done. And therefore the Supreme Court said that all these investigative agencies must be independent from the executive. It is very important because recently also one judgment of the Supreme Court, where they said that the CBI director who was appointed for 2 years, and they continued, the government decided to continue his appointment, and the Supreme Court said no, you cannot continue his appointment. After 2 years he has to be replaced by another person. So therefore in this case the Supreme Court pointed out how ingrained this whole corruption was, how people who belong to political parties were being let scot-free, no action was being taken, and therefore the Supreme Court set down guidelines as to how the CBI should be independent and there should be no control or supervision by the government. And therefore CBI was supposed to be, it is monitored by the Vigilance Commission, which is set up by a Vigilance Commission Act, and under that act those officers who are appointed in the Vigilance Commission are supposed to be independent. Today we know that there is no such thing as independence. All persons are being appointed by the political party in power, whoever it may be, even during, whether it was Congress or whether now, it has always been people being appointed through the government. Now this Lokpal and the Lokayukt Act was introduced in 2013. Basically it is to implement the Prevention of Corruption Act. So it is not something totally independent, it is to implement the Prevention of Corruption Act. But if we look at today, we have in Maharashtra the Lokayukt. I don't know if anyone has gone to the Lokayukt. People have gone? Yes. Have you found any result?
Not much.
Madam, if you write in English, they will dispose of. You write in Marathi, they will take some action.
They will take action.
Yeah, I went there. I told them, what is this? They're saying, sir, अगर आप मराठी में लिखोगे आपका action होगा. English में लिखोगे, then they created a online that nothing happens.
So,
they don't understand English words, nothing.
So anyway, I will end only this part. I just wanted to say that the Lokpal is a central Lokpal, and the Lokayukt are appointed at the state level. So who should be on the Lokpal again? It is supposed to be an independent body, but today it is completely controlled by the government in power. You are supposed to have a selection committee, and that selection committee appoints the members of the Lokpal. So you have one chairperson, and maximum people on the committee are 8 people, who have 50% of whom have to be judicial members and 50% have to be non-judicial members. Now, how do you appoint them? It is basically the Prime Minister, of course the Prime Minister, then the Lok Sabha member, then the opposition party member, and the CJ, the Chief Justice, or any person appointed by the CJ from the Supreme Court. And one eminent person. So these are the selection committees which appoints the Lokpal and the members in the Lokpal. Similarly, the same procedure is followed for the state government. But this never happens, and I don't want to name today's chairperson of Lokayukt, was of High Court judge, and he is now the chairperson. Unfortunately, not a single case really goes on against any officer or public officer where complaints are made by citizens. The second issue is that who are the people against whom offences can be registered? Can anyone say who are the people? Against whom can complaints be registered in the Lokpal or the Lokayukt?
Against bureaucrats and ministers.
Much more than that. It is the Prime Minister. Even against the Prime Minister it can be registered. Prime Minister, ministers, and then of course, category A, B, C, D employees of central government. So A, B, as everyone knows, are very high officials like Joint Secretary of the department, whatever, are all in that A, B category. C and D are the lower category of either staff, class 4 employees, class 3 employees, all of them come under this. Now, in a case of the Prime Minister, I'll finish in 5 minutes.
It's okay.
In the case of the Prime Minister, what happens is very interesting, that even though the Lokpal has a provision to prosecute the Prime Minister, but there are 2 issues on which it cannot. One is if it is connected with international issues, and the second one is, let me just find that. The security of the state, etc. So international relations and security of the state, these are the 2 conditions under which they cannot prosecute. But on other issues, say on corruption or on any other issue, prosecution can take place. But it has to be done by the full bench, not just 2 members of the Lokpal, but the full bench, whoever of 8 people have to look into the matter and pass a judgment. It has to be in camera so that nobody knows what's happening, and it cannot, even after a decision is taken, it cannot be publicized. So these are the weaknesses in the act, and therefore naturally the Lokpal or the Lokayukt, if it's the Chief Minister, in the Lokayukt it will be the Chief Minister, in Lokpal it will be the Prime Minister. People are scared to touch either the Prime Minister or the Chief Minister. The second issue is about these high officials of category A and B. What happens to that? So you can also file a case against the Joint Secretary, Deputy Secretary of a particular department, or the Chief Secretary. All these will come under A and B categories. You can file a complaint, but when a complaint is made, then it has to be transferred to the Vigilance Committee, and the Vigilance Commission will go into it and submit a report to the Lokpal. That is what will happen as far as your complaint for these class A and B employees. For C and D employees, the Lokpal or the Lokayukt can independently do it, and or they can send it to the commission, but the Lokpal would have the authority to take a final decision. Now it has 2 parts to it. One is that it has a prosecution wing, an inquiry wing and a prosecution wing. So just as in criminal cases, the police officer first conducts an inquiry, correct, before any action can be taken. He conducts an inquiry and then subsequently files a report, and based on that report, charge sheet is framed. Similarly, in a case before the Lokpal, there is an inquiry wing where inquiry is conducted, a preliminary inquiry is conducted into whatever complaint that you have made, and after the preliminary inquiry is over, a report is submitted, and that investigation report is then sent to the prosecution wing. So the second part of it is the prosecution wing, like the police officer's role. So the prosecution wing will then study the investigation report and send it to the court, which is called the special court under the Act. So you can imagine the long drawn out procedure. Though a timeline is set out, this whole procedure itself can take ages. And it is after the prosecution wing, while the matter is going on before the court, that the Lokpal can decide whether to sanction the proceeding. So you do not have to go up to the appropriate authority, but the Lokpal and the Lokayukt has the power to sanction the prosecution of that person concerned. Now this basically is really the Lokpal, and as we have seen, I tried to look up the website to see how many cases are filed in the Lokayukt. Hardly any important orders have been passed as far as Lokayukt. Lokpal, you can forget it. I mean, if you get to hear about some case, it will be in the press because that's a high, at a high level, a case is registered against either the ministers or the deputy secretaries and chief secretary, etc. So even the Lokpal has failed in what it is supposed to do, and I think that we must intervene in such matters also, because if we could make out a very strong case as far as, say, Lokayukt is concerned against any particular officer or any senior officer in the government or a police officer as far as corruption is concerned, because again it is restricted only to corruption, not to cases where, say, a death takes place or custodial death takes place. You cannot go under this act. So it's only related to corruption cases which are defined under the Prevention of Corruption Act that you can go under Lokpal. Thanks.
Rao Sahab, Kamlakarji, I believe you all have, Swarupji, you all have, and many other advocates over here must be facing some problem while, taking up cases of activists or governance issues. You all must be having queries surely. Do you all have to, do you all wish to ask anything? Or others also, everyone else?
Or make suggestions also.
Yeah.
Madam, actually, complaints, we file complaints, that should be made strong. Like RTA, there should be a time period to reply and resolve the complaint, put penalty on the officers, and put all complaint charge sheets on the website of the courts, all charge sheets website, so there will be no cheating, and all decisions, and after the decision of the judge, there should be feedback from both the parties. Then the cheating will stop. All departments.
Are there provisions, already such provisions there, or we'll have to fight for it?
See, this is a basic right that we have. It's not something, you need not have it in the law. You have a right to know as to what has happened. In fact, Shailesh Gandhi we were just discussing, Shailesh Gandhi is a person who has done a lot under the right to, and he was saying that we should get information from all police stations to show what they have done when an FIR is registered against particular cases, say police officers or government officials, not all FIRs. But when this is done, what progress has been made in that, what steps have been taken. This is something that we as citizens have a right to know. So I would suggest that, just making general statements like that, maybe from your local area, if people could find out like what steps have been taken against ABC officers, and then collect information on that. So then we can seek directions from the court saying that these were the steps that were required to be taken and have not been done, and that the officers should be directed. Such directions can be issued by the court, and these are all directions, like for example this Vineet Narayan's case where court has set down certain directions how the CBI should operate. Similar directions we can get from against officers or against police stations for carrying out proper investigation.
Madam, why not have citizens courts instead of having designated, this because all courts are depending on applications and now e-filing. So citizens courts direct action.
But for that a law has to be passed before citizens courts come in.
Is there any difference between corruption and misuse of power? Because Anti-Corruption Bureau investigates misuse of power also.
Yes.
So is it different? What is the difference? What is misuse of power?
So misuse of power should be in the context of getting some gain from it, right? If you are misusing the power, your power, I am the police officer and I am doing something which will benefit me for that. That's why I said in the beginning that it's not only gratification in terms of money, in terms of what you get, bribery, but also in terms of getting some benefit out of the dishonest work that you do. So some duty that is cast upon you, you are supposed to do A, B, C, D. But instead of doing that, you do something which is illegal in order to promote yourself. That is misuse of power. So that is also covered, yes.
So that section is
Yes.
codified.
Yes. But the problem is that you have to get permission from the appropriate authority. Like the 197 section, there is a similar provision here that you have to get sanction from the authority.
Which is that provision? Number?
17 something.
In the Prevention of Corruption Act.
Yeah.
17.
I'll just
17A.
No, not 17, it's 19. 19. It's called previous sanction necessary for prosecution. So, what's the point? Then you actually, another point that I wanted to point out was that the appropriate government, who is the appropriate government? So, if I am appointed by the state government, police officer, and the police officer appointed by the state government, and I am seeking sanction from the same authority that appoints me. Naturally, that appointing authority is going to favor me because I am the appointing authority. If anything adverse is said against the officer, it impacts my functioning also as a state government.
Right.
So therefore, the appointing authority or the appropriate authority or the appropriate government will 99%, if you look at all the cases, 99% they will exonerate the officer and say we will not give consent. So what is the purpose of this provision? Then it's almost like going back to as if no complaint had been made against the officer. What is the benefit of this act as far as citizens are concerned? Nothing. Because you are going to exonerate him. You are going to ultimately, the power is with you. It is not in the court where it should be. Ultimately, you should lead evidence. Ultimately, it should be left to the court to say whether he was actually performing his duty as per law or was he exceeding his jurisdiction. That only the court should decide. Here, it is given to the state government or the central government. So in all cases, I mean the cases that we are handling are all cases of this where officers have, say, murdered someone in police custody, or there's been some firing, or someone has been injured or assaulted by police officer. All these cases go before the government and they exonerate them.
That means government is encouraging corruption and to this level.
Yes.
Madam, these are all toothless bodies then.
Yeah, absolutely.
All our bodies are total.
Yeah, madam.
When we complain against government officer,
He's saying something.
Yeah.
when we
See,
complain against
government
government
is
to nowhere.
That's what. But
government.
for that I'll say, okay.
Government runs on behalf of governor.
Yes.
It is everywhere said governor. So then in that case, what is the role of governor in maintaining good governance?
But that is the sad part, that you know what happens. So as far as the role of the governor is concerned, there have been many cases where the governor is appointed by the ruling party, right? Whoever is the ruling party will appoint that governor. And suppose if the party in power in the central government party, whoever the party is also the government in the state government, then there's no such problem, because ultimately both are same. But if the government, the state government is an opposition party, then the governor who is appointed for that state will always be the governor appointed by the central government, correct? So it will never operate in unison. Both the state government will always be at odds. So you will find in Kerala, maximum number of bills which were introduced were basically they have to go for approval to the governor. So the governor, most of those cases rejected the bills.
Yeah.
Okay, now in a similar case where we had intervened in the Rajasthan, where the Rajasthan was the government was the Congress and the governor was of the ruling party, the Congress party had introduced a bill on gig workers. I don't know if all of you know, gig workers are a category of workers who do not get any benefit under labor laws. So a bill was introduced to protect them. Now that bill was drafted by many of us who've been working on labor issues. We had drafted that bill and then finally it was passed in the assembly. But when it was passed, it has to go through, after passing, it has to go to the governor for final approval. The governor sat on it for many months. Finally, we gave him some case laws which said that a governor cannot sit on a bill. Either he has to send it back to the assembly, and then if the assembly again approves it and it's again sent, then he has to approve it. Okay, that is the law. And ultimately he did pass it, he signed it. But in Kerala, as I said, almost about 20 to 30 bills were rejected by the governor, and he kept rejecting them. So finally, the Kerala government filed in the Supreme Court, and the Supreme Court said this is totally illegal, and sent it back to the governor for approval because the assembly had finally approved it. So there are such cases where law is broken, but ultimately, hopefully, sometime something good happens, and that is what happened. I mean, to your answer about the governor's role, that the governor also, it's not as if the governor is going to give justice on each and every issue. There can be a lot of obstacles for the any other bill or a bill which is in favor of some section of people is not permitted.
We are talking about corruption in other government authorities. What about judiciary? If a higher court finds out that there is a gross miscarriage of justice, I mean, they literally, what they call in Marathi, they tashe, I mean, they point out that despite the act, despite the evidences, the particular judge has passed an order overlooking even the Supreme Court rulings. So is there a mechanism so as to make the judges within the judiciary, or is there any other forum? Because as we say that the last resort for justice is judiciary for us. So this is number one question. Number two, we are talking of a lot of reforms. A lot of reforms are taking place in all the sectors. See, judiciary gives judgments, whereas other authorities, government authorities, they give decision. There is a difference between judgment and decision. Now there is a process. Say for example, you go in banking for sanctioning a loan. We go through a process. We submit the loan application and then a sanction letter is given. Why is there not shortening of judiciary that I file a petition, then I get a reply, written statements, and that's it. I mean, there has to be a time limit. There is a time limit of 180 days within which a written statement has to be given. Why go through the process? Within 6 months, all the statements, all the evidences are on record. If there are any witnesses, let them put in writing all whatever has to be said. They need not be called. Because I find that lot of 80% of the judiciary time goes in giving dates or for short distance. So is there anything being done to revamp the entire judicial process which is being carried out from the British time so that it is shortened? Now we say that justice delayed is justice denied. I mean, people go to judiciary only to harass somebody.
So I mean, just on that's a totally different topic and quite lengthy also, is the collegium that is appointed by the introduced by the Supreme Court because of some judgment. Now, earlier there was a provision which said that the government would also have a role in appointing Supreme Court judges. That was the earlier position which was challenged before the Supreme Court, and then the Supreme Court said this is illegal, it cannot be, and they set up a collegium system which is basically of the Chief Justice and 4 other senior members of the Supreme Court who will form the collegium. So what happens is that the judges that are say for example a judge has to be appointed to the Supreme Court, or some judge has to be transferred from some high court. Ultimately it is the collegium who decides it, and whoever proposes the name, so the name comes from the government, is approved by the collegium and then sent back to the government for final approval. So it is at that stage when the name is sent from the collegium to the central government that it is stalled, because the central government might not like that particular person who is being appointed. One example is of a gay person who was he's a lawyer and a very good lawyer, and everybody recognized him, he's a senior counsel, etc., etc. But when his name was suggested by the collegium and was sent to the government rejected it on the ground that his partner was some foreigner, and it might cause some secrets of the state being leaked out, which is not correct, because there are so many people who have foreign wives and foreign husbands, and nothing is said about that. But because that partner was gay and they did not approve of gay relationships, the government rejected it. So there are many such prejudices or fact that person is not liked by the government. Or there was also a case where in our Bombay High Court that a particular lawyer's name was suggested, because lawyers can be appointed even directly to the Supreme Court. So his name was suggested for the Supreme Court. Now it so happened that the lawyer who was working for a senior counsel had written several articles in the press against the government on many issues, on communal disharmony, on various other issues. He had written very strong articles against the government, and the government said that we cannot take him because of these articles. So the Supreme Court collegium said, how is he connected? He is working with a person who has given this is his opinion. Similarly, many people have opinions, but it doesn't mean that you have to practice it on the bench. So ultimately that name was rejected, and he also was not appointed. So there are certain things which goes on in the judiciary, unfortunately, which are the tussle between the government and the judiciary has been there. The second part about judges is that we should not forget that the judges have their own prejudices. Just because they are the judiciary doesn't mean that they are right. Whatever laws that they pass or whatever judgments they give does not mean that they are, because the Supreme Court judge has given. So, I mean, I can name so many judgments which are actually controversial, which are against the law, whatever existing law, they are against the constitution, yet such judgments have been passed by the Supreme Court. So and there are also cases, you must have heard of Prashant Bhushan. Have you heard of Prashant? So he had said very clearly, because at that time Arun Mishra and various other judges were openly pro-government. Even in their judgments you could see that they were openly pro-government. Any person who came complaining against the government, and if it was an important case or whatever, the judge would say that the judges would say that this petition should be dismissed. So Prashant Bhushan had openly said that this is the government speaking. The judges are actually speaking on behalf of the government, and they are not really giving any justice to people. So he was hauled up for contempt by those judges. Now when he was hauled up, there was a lot of hue and cry against that. Many of us protested, all the lawyers protested, some of the judges who had retired, they protested, and it became a big issue. So finally the Supreme Court said, okay, we will punish him, but he will have to pay 1 rupee. You remember all that? So 1 rupee was taken and became a big thing, and everybody circulated it, and it was a big victory for us. But remember that is because there was opposition to it from people, and unless we stand up and say something openly. So today lawyers are scared even to criticize the judgment. So the law is very clear that you can criticize a judgment. That does not make it a contempt of court, but you cannot personally attack the judge, right? So if I say tomorrow that this Chief Justice is so and so, whatever, he's corrupt, and without any evidence, then that is contempt of court. But if I say a judgment which has been given by him is wrong because of ABC reason, that is not contempt. And for that people should stand up. Even for that lawyers, I don't know lawyers sitting behind what they think about this, but many lawyers are scared to even criticize a judgment because they feel they will be hauled up. So I think the more we as lawyers stand up, then other people also, people who are citizens and who realize that this is wrong, will come and support. And once we do that, then things are going to change.
But there is no accountability forum within the judiciary.
No.
Madam, the collegium system, no, madam, why don't they give advertisement for other judges also to apply? Why it is a closed system, cage system?
For elections. Why they can stand for election and all?
Like the US system. US has that.
Yeah, US system.
So anyway,
Madam, what is deemed sanction? Tell me about deemed sanction.
deemed sanction.
Yeah, Supreme Court has given almost 3 months. If they ask for prosecution of a police officer, no, it is the deemed sanction.
If no reply comes from the appointing
Yes,
authority,
yes,
then
if
deemed.
no reply comes, yeah. If there is no reply within a particular period of time, then it is a deemed sanction.
90 days.
90 days, I
Yeah,
think.
90 days. 90 days.
It's 90 days to give a sanction. If they are taking advice from the Attorney General or anybody else, 30 more days are to be
That is
given.
4 months. That is 4 months.
I'm completely.
Let him finish.
If you know it, then I'll sit down. So totally it's 120 days. 90 days. That too, within that 90 days, they have to inform you that they're seeking advice from the Attorney General
Yeah.
or the Advocate General or whoever they want to take. And then they get 30 days extra. Otherwise, it's deemed and you can start the prosecution.
मैडम दिस
He
कंटेंट
wants to say something.
हाँ, एक मैटर में ये देखिए कि कितने फॉल्ट हैं। एक बड़ी कंपनी के बड़े अधिकारी ने अपनी होंडा से रिक्शे को उड़ाया, ड्राइवर के साथ 2 लोग घायल हो गए। वहाँ पर कोई गार्ड लोगों ने उनको भगाया, एक्टिविस्ट गया, एक्टिविस्ट ने उनको लेकर अस्पताल गया, पुलिस आई नहीं, अस्पताल लेके गया, अस्पताल में पुलिस नहीं है, यानी पुलिस होनी चाहिए सरकारी अस्पताल में, वो नहीं है। डॉक्टर ने क्या कोई पुलिस नहीं बुलाई, 4 घंटे तक वो एक्टिविस्ट उन लोगों का इलाज मिलाज एक्सरे वैक्सरे सब करवा के लिया। इसके बाद वो वहाँ पर पुलिस 112 में पुलिस को बुलाया, पुलिस ने उन लोगों का वहाँ कोई बयान नहीं लिया, फ्रैक्चर भी हुआ है, उनको बोला अस्पताल जाओ, वो अपने थाने जाओ। इन लोगों को लेके थाने गए, थाने में 3 बजे से रात के 9 बजे तक एफआईआर नहीं होती है। आरोपी जो है उसको बुलाया जाता है 3-4 घंटे के बाद, वो इन विक्टिम लोगों को डरा धमका करके एक को तो भगा देता है और एक तो खैर गार्डों ने पहले भगा दिया, और जो एक है उसकी द्वारा एफआईआर हुई। उस मामले में जब एफआईआर नहीं हो रही तो एक्टिविस्ट ने आवाज़ उठाई तो एक्टिविस्ट के ऊपर 353 वो जड़ दिया, और अभी जो है विक्टिम जिसकी तरफ से एफआईआर हुई है वो भी सामने वालों के साथ मिलकर के वो कर गया। अभी ये चीज़ हुई है, तो इसमें जो फॉल्ट है, सबसे पहली चीज़ अस्पताल में डॉक्टर पुलिस नहीं है, तो उसका फॉल्ट एक बनता है या नहीं। दूसरा, ये सीधे क्रिस्टल क्लियर था, 3 बजे अगर हम पहुंच गए हैं थाने तो 15-20 मिनट या आधे घंटे के अंदर एफआईआर होनी चाहिए थी। बहाना बनाया कि एमसीए नहीं आया है इसके लिए हम नहीं कर रहे, जबकि एमएलसी मेडिकल पेपर होने पर उस पर होना चाहिए था एफआईआर। तो इस व्यक्ति ने, अपने एक्टिविस्ट ने आवाज़ उठाई कि भाई मेडिकल पेपर पर एफआईआर हो सकती है, मगर टाइम पास हुआ पैसे खाने के लिए, मतलब जो भी मैनेज करने के लिए, और फिर टाइम पास उसको बाहर भगाना, ये सब चीज़ें इसके अंदर हुई। तो अभी इसमें कहाँ फॉल्ट इन लोगों ने किए हैं वो थोड़ा सा देखिए किस तरीके से हम करें।
तो इसलिए वो ये डिटेल में ना जाते हुए आपके पास अगर इतना इन्फॉर्मेशन है तो आप कोर्ट में जाना चाहिए, उनको ये करने के लिए, क्योंकि आप जो बोल रहे हो बहुत कन्विंसिंग है, जो क्योंकि इतना ये हुआ, डॉक्टर नहीं था वगैरह वगैरह, पुलिस नहीं था, तो जो ऑफिसर है जिसने कंप्लेन 4 घंटे के बाद उन्होंने लिया जो भी है, तो उसके पहले आप उनको ये देना चाहिए एक कंप्लेंट कि ये सब प्रोसेस कुछ तो रिकॉर्ड पे होना चाहिए कि ये प्रॉब्लम हुआ और आपने नहीं किया इम्प्लीमेंट, और फिर कोर्ट में जाना चाहिए। क्योंकि आपको अनलेस हम इंडिविजुअली ऑफिसर्स को ये नहीं करेंगे, रिस्पॉन्सिबल नहीं करेंगे, तो फिर कुछ सुधार होगा नहीं। तो एक है कि FIR इमीडिएटली रजिस्टर होना चाहिए था, नहीं हुआ। दूसरा था कि पुलिस हॉस्पिटल में फैलाना। अभी हमारा एक केस है जहाँ पे एक इंसिडेंट था कि लोग अपने फैमिली के अंदर घर के अंदर प्रेयर कर रहे थे, क्रिश्चियन फैमिली था, और वो सॉफ्ट मतलब कोई ये माइक के साथ नहीं, कुछ नहीं, सॉफ्टली अपना प्रेयर करते थे हर संडे को। फिर कुछ लोग आए और बहुत कुछ धमाल हो गया और फिर उनको प्रिवेंट किया गया, और फिर बाद में जब वो पुलिस स्टेशन गए तो पुलिस ने बोला आप नहीं कर सकते हो क्योंकि 5 से ज़्यादा लोग अंदर नहीं हो सकते। तो फैमिली के अंदर, घर के अंदर 5 से ज़्यादा नहीं हो, ये कौन सा कायदा है? और अगर समझो आपके पास 5 बच्चे हैं या 6 बच्चे हैं तो फिर इसका मतलब सिर्फ 5 ही रहना चाहिए। तो टोटल इलॉजिकल। और फिर अभी सोल्यूशन ये है कि वो जो फैमिली है वो नेचुरली डर गया है, वो पुलिस स्टेशन में जाना नहीं चाहते हैं। जो सोसाइटी के लोग हैं वो उनको सपोर्ट कर रहे हैं, लेकिन वो भी डर रहे हैं कि अगर हम उनको सपोर्ट करेंगे तो ये सब लोग आएंगे और हमको तंग करेंगे। तो इसलिए फिर हम लोग ने तय किया कि अभी हम एक लेटर डिटेल में ये सब जो आप जो बोल रहे हो वैसा डिटेल में एक लेटर उनको लिखना चाहिए, और फिर हम कोर्ट में जाने वाले हैं वो पुलिस ऑफिसर के खिलाफ।
अभी इसमें 41A का नोटिस देके इसको बुलाया जा रहा है, हम इनका एफिडेविट बना रहे हैं, और डॉक्टर अस्पताल में RTI लगा कि भाई आपके यहाँ उस दिन कोई पुलिस था नहीं था, या जो भी XYZ आपने ये जो भी किया वो ठीक। CCTV फुटेज पूरे मौजूद है वहाँ पर थाने में, जिसमें सारी जानकारी है कि भाई ये व्यक्ति ने तो किसी प्रकार का कोई सरकारी कार्य में बाधा दिया नहीं, एक्टिविस्ट ने, ये सब चीज़ उसके अंदर, तो वो सब हम मेंशन करते हुए लेटर भेज रहे हैं। और उसके बाद प्रोटेस्ट करेंगे थोड़ा DCP के पास जाके कि भाई ये मैटर का थाना चेंज किया जाए, क्योंकि सीनियर के ऊपर भी इसमें मेंशन हुआ है। सीनियर ने इसके साथ अभद्रता की, मतलब एक्टिविस्ट के साथ, तो उसका नाम सीनियर के बेस को ले लिया। तो ये तो अभी उस थाने में चल ही नहीं सकता मैटर, तो वो थाना चेंज करना, ये सब चीज़ हम करने की सोच रहे हैं। तो उसके ये तो पूरा एक एफिडेविट बना करके हम कंप्लीट कर रहे हैं। अब वो जो विक्टिम है जिसकी तरफ से FIR हुई, जिसके लिए लड़ा, वो अब सामने वाले मैनेज हो गया। उससे हमने कहा कि इस FIR में क्या ये करो, मतलब कम से कम साक्षी बनो, तो वो नहीं आ रहा। तो अभी हम उसको भी नोटिस दे रहे हैं, दोनों 3 लोग हैं, जो 2 लोग, कि भाई आप वहाँ पर थे मौजूद और ये चीज़ हुई है, इसको एक्सेप्ट करते हो या नहीं करते हो, जो भी आप जानकारी दो हमें 10 दिन के अंदर, नहीं तो ये माना जाएगा एक्सेप्ट है। MHRC में भी रजिस्टर्ड हो गया ये केस, ये चीज़ का। तो इस ढंग से हम लोग जा रहे हैं। तो मुझे ये चाहना था कि मतलब और भी कुछ है क्या, या ये रास्ता?
Madam, we talk about fast track courts, but why you want written reply, written affidavit evidence, written arguments? Directly, I complain against you, you come say yes, no, and you file, and then have arguments on the 3rd date. Or for 3 months, let each other give without the court interference and the evidence of each other, and then have this. And why the court takes 12 years? They can't see the documents and give direct justice.
So problem ये है कि ये सिर्फ लोअर कोर्ट में तो और भी हालत खराब है, लेकिन मैं आपको हमारा एक्सपीरियंस हाई कोर्ट में बताते हैं कि हमारे जो क्लाइंट्स है वो बार बार पूछेंगे अरे हमारा केस का क्या हुआ, आप कुछ कर नहीं रहे हो, वो मेंशन किया या नहीं मेंशन किया, फिर मेंशन किया तो फिर क्या हो गया और इतना लंबा डेट क्यों हुआ। तो हम लोग खुद जो लॉयर्स हैं वो इतना कंटाल आ गया है, वी गॉट सो फेड अप कि we also don't want to practice in the court because the entire procedure is so long and lengthy. So you go to court, you file a petition which you need to hear immediately because some say, for example, construction is going on somewhere which is totally illegal. Some people are going to be evicted tomorrow. Court says, okay, you file, tells the other side, gives notice to them, okay, we give notice. Then after giving notice, they have to file a reply. But why should they file a reply? Jab issue is so important, people are going to be evicted, you immediately give a stay and let them say whatever they want to say later on. But no, So the entire procedure, then they give time for them to file reply. Then they raise new issues in the reply. Then you want to counter those replies because you can't let it go. If you let it go, then the court will say, see, you did not deny that. So you have to deny it. So then if you deny it and then finally it comes up for hearing, the judge does not have time, or some other matter is more important than your matter, and then again dates are given. So it's like this, if I give you the list of dates that are given, forget the procedure, आप procedure का बात कर रहे हो, dates लंबा 1 महीने का, 2 महीने का dates आप mention करने जाओ, तो जज बोलेंगे नहीं हमारे पास time नहीं है. So all this is a mockery of any justice that you are trying to get.
Madam, written document देने के बाद भी arguments होते. I mean arguments, advocates they read out what is written. वो पढ़ नहीं सकते क्या? वो सब दिया हुआ है, आप पढ़ो उसमें से judgment दे दो. Why you need a framing of issues?
So I'm just saying, I mean, point is no point.
Prayers तो दिए हुए. Again why you need framing of issues? Prayer दिए हुए, documents दिए हुए, petition है, written statement है, counter written statement है, सब कुछ है. Read it and give judgment. Then you need argument. Then you need cross examination. पूरा लंबा process चलता है. Ma'am, I have one question.
He has one. Just let him.
It's basically you need to be like Salman Khan, where getting bail is faster than making bail.
Yes, really. And if you are known face and you are famous and rich,
The driverless car killing someone.
एक मैटर में बात करता हूँ. एक चलते मैटर हुआ, उसके अंदर पुलिस ने एक को मारा और पुलिस ने चलते खुद के ऊपर कि इसने मेरे को मारा ऐसा बनाया. उसमें बिना किसी उसके एडिशनल जो अपने एसपी उसने उसकी जांच करी. जांच करने के बाद दूसरे दिन फिर खुद फिर से दूसरी जांच करी क्योंकि बयान चेंज है. फिर उसके बाद उसने इसको दोषी जिसको मारा गया है जो अभी बेहोश है उसको दोषी भी करार देके उसको FIR 307 ये वो सब लगा दिया. इसके बाद उसने क्या बोलते जब थोड़ा होश में आया उसने कंप्लेंट करी, जो कंप्लेंट करी बयान लिखा वो सब गायब कर दिया गया. फिर आईजी ने इस मामले में स्पेशल आईजी ने अपने डीजीपी के द्वारा अपॉइंट होकर, यानी अपॉइंट बोले तो फोन पर अपॉइंट, और उस पर उसने रिपोर्ट बनाई. उसने सीसीटीवी फुटेज सब, इसका मोबाइल गायब कर दिया था, वो सब आ गया सामने. इस रिपोर्ट के आधार पर उसने सीधे से बोला ये संदेह है गलत मतलब ढंग से FIR करी गई है. ये जो उन्होंने आईजी ने बोल दी. इसके बाद तीसरी ये जो है जब इसमें कंप्लेंट होती है तो 197 का मतलब उसके ऊपर FIR वो करने के लिए तो 197 का एक लोअर ऑफिसर मतलब PI वो करता है, कहते हैं कि मतलब 197 में अप्रूव नहीं दिया जाएगा ऐसा ये चीज़. इसके बाद फिर से क्या बोलते हैं एक उससे मतलब SP लेवल का ऑफिसर और IG लेवल का ऑफिसर जांच कर चुका है. उसके बाद आखिर में एक और फिर PI वो जांच करता है. अच्छा, PI की जांच की हम जो रेफरेंस रिपोर्ट है उसमें रेफरेंस रिपोर्ट में एक नंबर डाला हुआ है. इस रेफरेंस पर हम क्या कहते हैं जांच कर रहे हैं. वो पेपर मांगा जा रहा है, वो पेपर में बराबर से तारीख नहीं डली, कुछ नहीं है, वो पेपर नहीं दिया जा रहा है. अब इन सब चीज़ का बेस लेकर के पूरा मैटर ह्यूमन राइट में चल रहा है. सामने वालों ने लगा दिया कि क्या कहते नहीं ये मैटर तो उसमें भी चल रहा है अपने लोअर कोर्ट में भी, इसलिए यहाँ पर ना चलाया जाए इस चीज़ को. तो यहाँ पर सबसे बड़ा चीज़ यह है कि एक अगर IG स्तर के ऑफिसर ने एक रिपोर्ट बना दी है उसके ऊपर किसी ने भी कोई ऑब्जेक्शन नहीं लिया है तो उस रिपोर्ट को ही फाइनल माना जाना चाहिए. ह्यूमन राइट्स ने भी मानना चाहिए. मगर उसके बावजूद उसका बेस लेकर के मतलब कि दूसरे ऑफिसर ने ये कर दिया है उसमें इसको यानी इसको दोषी करार दे दिया है और ऑफिसर की रिपोर्ट उसको यानी जिसने FIR करी है 307 की उसको सही मान लिया गया है ऐसा उसने लिखा है. तो ये चीज़ क्या मान्य हो सकती है क्या?
उसके ऊपर मेरे को शॉर्ट में इतना ही बोलना है कि ह्यूमन राइट्स कमीशन मेरा ऐसा मत है कि कुछ फायदा नहीं है उधर जाकर. और वो एक कारण ये है कि ह्यूमन राइट्स कमीशन को कुछ पावर नहीं है. तो अगर समझो एक तरफ से ऑपोजिट पार्टी अगर समझो हम लोग ऑलरेडी हाई कोर्ट में हैं ये इशू को लेकर या नीचे वाले कोर्ट में है तो उनका एक बहुत अच्छा ऑब्जेक्शन ये रहता है कि मैटर ऑलरेडी पेंडिंग है इधर नहीं होना चाहिए और नॉर्मली वो एक्सेप्ट करते हैं. यस एक मिनट. दूसरा पॉइंट ये है कि ह्यूमन राइट्स कमीशन को कुछ पावर ही नहीं है. वो अपना टाइम लेते रहते हैं और लोगों को लगता है अरे हमको कुछ जस्टिस मिलने वाला है, ये हमारा बात कितना अच्छी तरह से सुनते हैं तो वो आपको सुनेंगे, आपको पूरा अपॉर्चुनिटी देंगे, लेकिन फाइनली आप देखो जितना भी हम लोग ने ह्यूमन राइट्स कमीशन के ऊपर थोड़ा काम किया है देखने के लिए कि क्या क्या ऑर्डर्स उन्होंने पास किया है। और ऐसे भी एक हमारा खुद का केस है वैकेंसीज के बारे में, क्योंकि ह्यूमन राइट्स कमीशन बोलता है हमारे पास स्टाफ नहीं है, ये नहीं है, वो नहीं है, तो हम लोगों ने एक पिटीशन फाइल किया कि इनको स्टाफ मिलना चाहिए ताकि और ऑर्डर्स बराबर हो सकता है वगैरह वगैरह। अभी वो मैटर ह्यूमन राइट्स कमीशन में चल रहा है कितने साल से, 2 साल से, जो इतना इम्पोर्टेंट इश्यू है, क्योंकि वो उनको अदर साइड को पूरा टाइम देते हैं, आप फाइल करो एफिडेविट, आप ये करो वो करो, लेकिन हमको मालूम है कि कुछ इसमें से निकलने वाला नहीं है। अल्टीमेटली एक्चुअली हाई कोर्ट में हमको जाना ही पड़ेगा, लेकिन लोग ये गुमराह में रहते हैं कि अरे हमको कुछ न्याय इधर ह्यूमन राइट्स में मिलेगा।
अभी इसी में ह्यूमन राइट्स ने हमारे मामले में एक ये दिया 25,000 का कंपनसेशन, और सामने वाले को क्या बोलते हैं एक्शन लेने के लिए ऑर्डर दिया। ये ह्यूमन राइट्स का ऑर्डर है। इसके पीछे हम पढ़े तो इन लोगों ने डीजीपी और ये अपने एडिशनल सीपी वगैरह ने उसको निर्दोष करार दे दिया। ह्यूमन राइट्स ने उसको दोषी करार दिया है और इन लोगों ने निर्दोष करार दे दिया और उसको बचा लिया है। अब हम इस मामले में जा रहे हैं, 5 लोग हैं, 5 लोगों को हम पार्टी बना रहे हैं, डीजीपी वर्ग को उनको सो कॉज नोटिस दे रहे हैं और ह्यूमन राइट्स को सू मोटो दे रहे हैं। तो मेरे ख्याल से ये सही है या गलत है?
सही है।
इस बेस को लेकर के चले सू मोटो ले कि भाई जब आपका पावर ही यूज नहीं कर रहे ये लोग, आपके ऑर्डर को यूज नहीं कर रहे, तो फिर आप बंद कर लीजिए ना अपना दुकान।
उन्होंने ऑर्डर दिया तो ऑर्डर का पालन करना चाहिए,
वो नहीं कर रहा इन्होंने।
Gayatri ji, Shivnarayan ji has plenty of cases, plenty of such issues. You'll have to sit one full day with him and keep answering. That. Lovely. So, and of course, there are some more issues that need to be, which I recollected just now. One is about Prakash Singh case in Supreme Court, order of police reforms. That needs to be, of course, we all need to know how far it has reached. Wonderful order had been given in the Prakash Singh case, and how keen has the governments of states, all India, UT and states of India, have implemented or in the process, or how we can expedite it. That needs to be done, because excellent order had been given. Prakash Singh has come on and off, comes to Mumbai and meets us also. So we need to know your opinion on that. What we can do as activists, as a group of lawyers. You have your own network of lawyers. We all have network of activists and all that. In some way or the other, how we can, collaborate and take this forward. Okay, so that's one thing. Second thing is there are several activists over here affected by deputy registrars, corruption or inaction or whatever. One leader over here is of course Vasan Sinha. All the lots of problems are there in CHS, Deputy Registrar's Office, up till the Cooperative Commissioner, up till the Additional Commissioner of Cooperative Department Ministry. There's so much lethargy, and of course, naturally, they get managed by the managing committee and all the corruption money and all that. So how we can take this forward? We break our heads at the registrar's level, Deputy Registrar's level. RTIs they don't reply to, don't give the information. So that's also one thing that we need to know from you, that how we can take this forward.
Sir, one more thing can I add? When an order is given, that is if the case is closed, after of course sometimes it happens 1 year, 2 years and all that, actually they should not have more than 3 sittings. That is, after 3 adjournments they have to close the case, whatever it is. And the order has to be given within 90 days. This is as per Supreme Court order. Now I find that in my own case, where an order was given by the Deputy Registrar against the Secretary, he had removed the Secretary. The Secretary went in appeal to the DJR, and a person who doesn't even have a proper share certificate, that apart, second day I appeared in person and he had put me as a respondent and the society also as a respondent. So when I appeared in person and I told the DJR that this is a problem, he closed the case, second hearing itself. First hearing I didn't go, I couldn't go for some reason. And second hearing I went and explained the matter to him and he closed the case. Okay, after that 5 months are over. This is open and shut case. For that, why it should take 5 months is my point. It can be given within 15 days. There's no case at all. There's no masala in this case at all. Okay, but why not in 15 days? 90 days is the maximum Supreme Court. That is a contempt also, right?
Yeah.
So why it is taking 5 months?
All right, she'll answer that later on. She'll apply her mind
It's
to
not
that.
for me,
And
for
third thing,
everyone.
yes,
I'm
yes.
talking for everyone.
And third thing, after this break, we'll like to speak you to speak upon is we all are affected by the bad governance. Okay, lawyers also face that in the courts, and they also realize what things are going on. Yes, you all have your limitations. I understand. We have our limitations of having no power, but we have a fire in the belly to bring about a change. Okay, how we can collaborate? Kindly apply our mind whether we can take this forward in some way or the other. Getting better judicial reforms, better police reforms, and in general good governance. How we can apply your mind. Maybe you might not be able to offhand give the reply now. No problem. Maybe in due course of time we need to amalgamate and take this forward. So we'll take a break. Before that, a small thing which I've forgotten to tell you all, and you all must have read the invite to this program, is that to offset the expenses of the hall and refreshments and all that, some people have come forward to sponsor it. We are grateful for that. We have kept a donation box. Can you please, Dheerajji, raise it? We have kept a donation, voluntary contribution box over here. Okay. In the break or after this thing, you all may contribute whatever you want. There's no compulsion whatsoever. Whatever you feel can be a contribution for this event. Can you put it over here? Till then, we'll take a small break, Gayatriji, if you don't mind. All right. And please come back after say 10 minutes or so. Take a break, please. Refreshment. Thank you so much. Better. Please keep quiet, Sunny. Please wait. All right. Now we'll continue with the last part of our session today. As I've said before ending this thing, our first session, Gayatriji, we request that you speak on. If you can give us more guidance on police reforms, how we can collaborate, how far it has gone, and how we can take it forward. That's one thing. Second thing is the problems faced by residents of cooperative housing societies, where they face this, they break their head over the wall at the registrar's office. So how that can be also resolved, or what can be done? Of course, non-implementation of law is a big problem. No accountability from the powers that be, that is the cooperative commissioner or the cooperative minister or the chief minister. These are the three main authorities who can do something about it, can't do it. So how do we move forward now? That's another thing. Third thing, as I said, I'll just revise this third point also. How you as a representative of the lawyers, senior lawyers and everyone, and the group of lawyers also in Bombay and Supreme Court, and activists all over, not only in Mumbai. Mumbai also there's a network of activists who are doing their best with little guidance from lawyers and legal experts in our group. But overall, if something more cogent action can be taken, to bring about better governance. Now, as you know very well, we are going towards dictatorship. Okay, from 2019 onwards, we are moving in that direction, fast moving in that direction. All our liberties are being, snatched away from us. Activists, journalists being put in jail for frivolous reasons. So all these things are going on. How we can bring a halt to this? Somewhere or the other, if our country has to be better ruled, or there should be, better life in our with the citizens, then we'll have to have better governance. Otherwise, all this is not possible. Going power in the hands of a few, by hook or by crook, that's what has happened, as we all know. How do we halt that? I mean, this way, if we have to sit quiet or not make enough noise, we have had it. Maybe after 2024, we may not be able to speak so freely as we do over here. So we don't know. So how we can, in a way, bring a halt to this, try to reverse the trend, get in good governance, make our India so make it India as it was envisioned. So that's what I want also, a request. And another thing someone had told me outside just now, okay, how citizens can, take in-person petitions in court. See, here we are dependent on advocates who have their priorities. Okay, maybe builders issues, maybe CHS issues, maybe whatever, consumer issues, whatever. So they have their priorities, and it will not go the way a litigant wants, like they are frustrated. Of course, slow judiciary is there, corruption in judiciary may be there, fine. So how we can, expertly take our cases forward in the court? Maybe if you want to keep a lawyer, fine. That how we can keep a watch on him so that he doesn't play mischief with us. That's the and another few points which Kamlakarji wanted to say. Kamlakarji, do you wish to? Yeah. So please kindly, if you can one by one reply on that. Another request is, as someone else told me, that there are few activists well known whose articles come in papers, news items come in paper by say Jitendra Gadge or Anil Galgali. These are the people who file RTIs to expose the mischief in the government, right? They have the stamina, they have the resources. I'm glad. Here also, we also in our small way can do it. Well, what problems we face filing of FIR, isn't it? That's the initial thing which everyone faces. कि भाई cognizable offence है, clear cut cheating है, clear cut ये हुआ, वो हुआ, law violation हुआ, and we are brought into the notice of the senior PI, and yet he sleeps over it. Now, in a way, a thing that can be done that he has suggested is file RTI in every police station. ACP and senior PI are the PIOs. Now recently they say that senior PI has been made the PIO of police station. Never mind, whoever it is, PIO, Palada police station, ask them how many cases, how many complaints they have received, how many FIRs have been filed, how many you all haven't replied to, how many you have converted into NCs only. So by this, they know that public is keeping a watch on my complaints received by me. It's a way to do that. There's no harm in that. At the most, what can happen is they might sleep over it, they might not give the reply. Fine. But receiving plenty of RTI applications in the police station itself is a way to bring to their notice that we're keeping a watch on what you are doing over there, sitting over there. So please do that. Kamlakarji, put your points also if you wish.
इस माध्यम से मैं गायत्री मैडम से रिक्वेस्ट करना चाहता हूँ कि यू हैव गॉट अ वेल सेटल्ड एसोसिएशन एंड people around you to work for larger public interest. So it would be great if all we can jointly work together as an activist and as a lawyer and your group. It will be a great moral confidence for us that we have got a team of efficient lawyers in case of emergencies or to raise good issues. Now, tomorrow I want your prayers for me for tomorrow. Will you pray for me? Yes. Tomorrow सुप्रीम कोर्ट में मेरा 40,000 करोड़ का म्हाडा का फ्रॉड के बारे में हियरिंग है, फाइनल हियरिंग है वोका के सामने. एंड इन दिस मैटर शॉर्ट में बताता हूँ कि आई हैव एक्सपोज्ड ए फ्रॉड ऑफ 40,000 crores of म्हाडा surplus area not being surrendered. Bombay High Court was pleased to pass an order in my favor for registration of FIR against all those concerned म्हाडा ऑफिसर्स. अनफॉर्चुनेटली 40,000 करोड़ देने के बदले गवर्नमेंट ने मेरे खिलाफ SLP फाइल किया और मुझे खड्डे में डाल दिया. और अब कल उसकी फाइनल हियरिंग है. एंड मुंबई शहर में पेंडसे और सिद्धि भोसले ने मुझे हेल्प किया, उन्होंने फ्री ऑफ कॉस्ट मेरा काम किया. अब हाई कोर्ट में ओम प्रकाश परिहार करके वो इज आर्गिंग फॉर मी. टुमारो ही विल बी आर्गिंग द डेलीगेट सुप्रीम कोर्ट. तो आई वांट ऑल योर प्रेयर्स बिकॉज ये अगर कल हमारे फेवर में आ गया तो इट विल सेंड अ रिंगिंग बेल्स टू ऑल द IAS ऑफिसर्स एंड IPS ऑफिसर्स दैट आप आज करोगे तो 10 साल के बाद वो ऊपर आने वाला है. ये सिग्नल हमको भेजना है और इसलिए मुझे आप सबका प्रेयर्स चाहिए. मुझे सिर्फ प्रेयर से बचा सकते हैं, कोई इंसान मुझे नहीं बचा सकता. तो आप सभी लोग अपने प्रेयर्स में रोज मेरा नाम लीजिए कि भाई इसको इतनी ताकत दे कि मैं हर चीज जो करता हूँ उसको सक्सेस दे.
सर आप ही जीतोगे,
आप जीतोगे, बस हो गया.
ये दुआ है सर.
और दूसरी बात यह है कि मैडम मैं आपसे रिक्वेस्ट करता हूँ कि वी वांट योर असिस्टेंस. अभी मैंने आपको बताया कि हाई पावर कमिटी ने जो मेरा मैटर रिजेक्ट किया है, जबकि उनको अथॉरिटी नहीं है. आई विल गेट दोस पेपर्स बिकॉज आई नॉट येट रिसीव्ड द ऑर्डर. तो मैं ऑर्डर मुझे आज में मिल जाएगा. सो आई वुड लाइक टू मीट यू सो दैट वी कैन टेक दैट मैटर इन द हाई कोर्ट फॉर इट एंड सेट अ प्रेसिडेंट की हाई पावर कमिटी हैज गॉट नो राइट authority to conduct such hearings where a complaint is filed before the police department for offence for a cognizable offence. So that we will send a precedent. But the most important thing is, मैंने अजय मेहता के खिलाफ मजिस्ट्रेट कोर्ट में कंप्लेंट फाइल की थी. उन्होंने सैंक्शन के हिसाब से रिजेक्ट किया. नाउ द मैटर इज बिफोर द सेशन कोर्ट he has passed an illegal circular stating that as per law, whenever a 33(7) में जब डेवलपमेंट होता है तो रिहैब बिल्डिंग के ओसी देने के पहले म्हाडा का एनओसी लेना जरूरी है और म्हाडा के एनओसी लेने के पहले उनको सरप्लस सरेंडर करना है, सरप्लस एरिया जो उनको देना है वो सरेंडर करना है, इसलिए वो ये रखा है 10/6/2002 का सर्कुलर है और हाईकोर्ट की जजमेंट है। इसके बावजूद अजय मेहता ने गलत सर्कुलर पास किया कि रिहैब बिल्डिंग के लिए म्हाडा का एनओसी की जरूरत नहीं है। उसके बाद में हमने चीफ इंजीनियर को ये भेजा कि गवर्नमेंट ने बिल्डर्स का ये जो है रिजेक्ट किया है, गवर्नमेंट ने 2 से 3 बार रिजेक्ट किया हुआ है और इसके बावजूद ये बताने के बावजूद जो चीफ इंजीनियर ने अजय मेहता को बताया कि वी हैव टू विड्रॉ दिस बिकॉज द गवर्नमेंट हैज नॉट गिवन एंड इट इज अगेंस्ट द हाई कोर्ट ऑर्डर। उसने बोला कि यू गो अहेड, आई एम गोइंग टू पास। तो मैंने उनको ही खाली आरोपी किया, बाकी को आरोपी नहीं किया। तो अब ये बात आ जाएगी कि वेदर दैट सर्कुलर शुड बी चैलेंज्ड and even if not required, we should challenge the circular because वो circular की वजह से एक बड़े बिल्डर को हजारों करोड़ का फायदा होगा। तो so these two issues I request you to help us to take it to a logical end and with your expertise I definitely think कि कल का जीत के बाद ये हमारी दूसरी और तीसरी जीत भी हो जाएगी। और तीसरी बात ये है कि 17A this is absolutely an in fact when I speak to anti-corruption officers also वो भी कहते हैं कि हमको तो हाथ में बंगड़ी डाल के रखा है, हम कुछ नहीं कर सकते, इसलिए हमारा खाली 5 FIR हो गया क्योंकि ऊपर से आता है और रिप्लाई आता है। The other point in 17A is 17. The other point of 17A is it is said that the sanctions are given within 3 months, but 197 या 156 या 190 का इसमें क्या लिखा है? It will be deemed sanction after 3 months. That deemed sanction is willfully and deliberately avoided in PCI. But apart from that, even if it is avoided, there are Supreme Court judgments, Vinay Jain and Manmohan Singh. वो दोनों जजमेंट ने कि 3 महीने में अगर नहीं हुआ तो it is deemed sanction. But PC Act is not, anti-corruption is not following that. In my case, they also did the same thing when अपना धर्माधिकारी साहब said you register the offence, तो PC बोला हम नहीं करने वाले। Then he directed the EOW to register an offence. So this is how the anti-corruption department is destroying the fabric of their work, and we need to teach these corrupt public servants who are taking disadvantage of the law. तो और कुछ हमको ये बताने की तरह many issues where a common man is being put to difficulties. So as and time requires, आप अगर हमको मार्गदर्शन करेंगे, because we are good fighters, but we require ammunitions like you behind us. Otherwise हम कहीं भी जाके खड्डे में गिर जाएंगे. So with your support, we will definitely do something good for Mumbai. And very shortly, I will meet you on this high power committee and circular matter to file a writ or a PI, whatever is required. And again, I remind you that we would like to work with you as a joint venture, and please consider our request. Thank you.
Madam attends BMC matters also.
Yeah, I do, yeah.
Illegal constructions.
Yeah, that's some major mad work.
Sorry.
You are illegal constructions, you know. BMC illegal constructions.
Sorry. Yeah.
Very
It's
important.
beautiful.
Very
Sorry, thank you. Thank you. I have been fighting against for last since 2021 against the illegal beautification which is carried out in Mumbai on footpath, roads and traffic items. And these all are illegal constructions, and because the chief engineer roads
Waste of public money.
yeah, and the chief engineer roads has given in writing it violates the circular 14/12/99 which clearly says there can be no temporary and permanent construction on road footpaths. Now the DMC issued a direction of demolition, then she got the heat of it, and now they are wanting to change the circular 14/12/99. That is why I told you now people are wanting to change law to do illegal things. And now the day before yesterday, last Monday, I met Additional Municipal Commissioner Joshi Madam. He says we will change circular. You go to the court. I said, why are you sitting here as an executive? Because you are telling me to. You give me in writing that I should move the court. She could not answer, and that is how these are also the very. I have done all the homework. My writ is also almost ready. I have prepared the writ also almost ready. and criminal complaint is also almost, but I alone can't reach it. It is becoming very difficult for me to reach. But I can prepare the body, and then the follow-up, I need people like you to support me. So I will come with these 3 matters. Thank you so much for reminding me. Thank you. Because this is 4,500 crores now, and every year they will be spending thousands of crores. But latest I want to tell you, in BMC there is a vacancy shortage of staff of almost 50%. I have taken out in my view ward itself 50% staff नहीं है, और उसमें से 40% इलेक्शन को गया है, और एक्चुअली काम करने के लिए कोई नहीं। अभी मैंने एडिशनल म्युनिसिपल कमिश्नर को नोटिस भेजा है कि इतने छोटे स्टाफ में हमारे पॉलिटिशियंस और मिनिस्टर्स इनको अपने ऑफिस में बुलाते हैं, 1 बजे से 6 बजे तक, 8 बजे तक, 9 बजे तक रुकाते हैं, और यहाँ काम नहीं होता है। तो अगर वीसी फैसिलिटीज है तो यू डायरेक्ट देम टू गो फॉर वीसी फैसिलिटीज, और हमारे पब्लिक सर्वेंट्स को उनके ऑफिस में 8-8 घंटा रुकने के लिए मत लगाओ। इसके लिए अभी मैंने कल मेल भेजा है, और मंडे या ट्यूसडे व्हेन आई एम गोइंग आई विल बी क्रिएटिंग अ वीडियो आउटसाइड आवर ऑफिस एंड सेइंग दैट यू आंसर माय क्वेश्चंस।
Sir, put it on video so all of us.
मैंने डाला है कल का, इसमें मैंने डाला है सोशल मीडिया में डाला है। तो आप लोग सब, जब मेरा सोशल मीडिया में कुछ आता है तो सब प्लीज लाइक रीट्वीट या फॉरवर्ड भी कीजिए।
Put it on mail also, we forward mail.
तो आप लोग जरा प्लीज हेल्प कीजिए कि कोई पब्लिक ओपिनियन के सिवाय कुछ नहीं होने वाला है। मैं अकेला कितना भी चिल्लाऊं, कितना भी लड़ूं, इट विल नॉट सफाइज अनलेस एंड अंटिल देयर इज अ ग्रेट पब्लिक अवेयरनेस। थैंक यू सो मच। थैंक यू।
So I will conclude. We have 5 minutes. I just very quickly just point out 2-3 issues. One is about police reforms. Is a very long discussion. I would suggest that people read the judgment of the Supreme Court and see, because nothing has happened. There will be no progress in that whatever directions were issued by the Supreme Court. So we need to just identify amongst ourselves. There are many issues which various organizations are following up on, but we can, if we read it and see how does it help us, or how can we ensure that those suggestions can be implemented, we need to do that. So that maybe one session also could be on what those police reforms are, what we can do, etc. That are much more detailed discussion we should take place, because the thing is that nothing has happened. Even if you speak to Prakash, he will tell you that he is frustrated. And there are many issues like how can we better reform the police as an institution, as police officers functioning within the existing system. What can we do? That only as activists, you people can suggest what are the changes that require to be made. As lawyers, of course, there are other legal issues connected. The second thing that I wanted to say was that on the CHS, the society's functioning, I think that there are many issues regarding corruption. And corruption per se as a general word is fine, but when you go to court, you have to give very concrete examples of what that corruption is. So we should remember, that's why I was talking to some of them saying that hum ye corruption case file karenge वगैरह. That is not so simple. So when you are talking of the corruption of the registrar of societies, you need to have specific examples. Why do you say it's not only question of delay, it's not only a question of dates हमको मिला, लंबा मिला, उसने reply file नहीं किया, what you were saying. It's not only that. You must be able to show, because being lethargic or not giving dates is not an offence. And High Court is not going to, even if you go to the High Court will say we are not concerned with it, you deal with it at that level. You have to make, for delay and all that, you have to keep making applications before the registrar say, why have you not gone, etc., gone on with the matter. वो सब applications आपको lower court में करना पड़ेगा. But that is one part. And secondly, corruption, आपके पास क्या एग्जाम्पल है कि उन्होंने पैसा लिया from some party, they have taken, the registrar has taken money. What proved you? It's very difficult. Even on when I was in the labor courts and all that, I knew that so and so labor court judge has taken money from so and so company. We all knew that. But to file a case against that judge is very difficult because you are not able to get any proof. So we have to work more in terms of collecting information. Wherever, in whichever area we are working, we need to do the CID giri work of getting information and making a strong case out of whatever we've got. That's my second suggestion. Third is that, as far as, I don't know if Chandni is here. She's gone? Okay, so basically we've been working on various civil rights issues, and right now we've been working with some groups on hate speech. So there are several groups, and I would suggest there are some criminal lawyers here, that if we can collaborate at least at that level, because as I was telling them, we maybe in the High Court we are there, but at the magistrate level, we would like to, there are many clients who come to us, and sure, if there are lawyers here who are working on that issue, we would like to refer those cases to them also, because we know that they are sincere and working on these issues. So that sort of collaboration we can do. Secondly, the collaboration also can be at the level where we exchange information. Like for example, we might have information about some cases at the Supreme Court level, or some judgments which are in our favor, which we can use at the lower court level. So that exchange of information also is important. So that collaboration, at least amongst lawyers who are here and who are doing similar work, if we can collaborate together on these issues, it would be very good, because we need at lower court lawyers also to be active on these issues. That's a second suggestion. Third was that, as I said, we've been working on various civil liberties issues also. So if people, whenever those programs come up where we are organizing something, we will definitely call you people also, and similarly vice versa. If we could exchange information on that, it would help, because you people are working at the grassroots level, you might be at the High Court level or more on the legal issue. So if we could exchange information on that and collaborate on these issues, it would be good. The third suggestion was that when you are talking of PIL, filing PIL, that's not such a simple issue कि हम अभी ये issue है अभी हम PIL file करेंगे, because we need to do a lot of research on a particular issue. So say for example, issue of illegal constructions. If you're talking of filing a case against, say, the CEO of SRA for whatever reasons, for corruption, you need examples to show that that corruption took place. We can't just say he's a bad officer or he joined hands with the builder. So you need, so therefore when we are drafting PIL, we have to be very, it's not just a legal provision, but more in terms of getting actual information, because the court will also look into on what basis have you come to the court, what material you have. So that research has to be done, and I think that research is the most basic thing. Law will come later on. First is the research. So research, unless we do a proper research on whatever particular issue we are doing, our PL is not going to succeed. Most of our PLs which we file is after a great deal of research, not only with the activists, but also getting information from other cities, other high courts where similar cases have been filed, getting out judgments on that, getting out issues which have succeeded in other states, giving examples of that. So many such issues we need to cover in the PIL, and for that any help you people need, we are all there. There are a number of lawyers working on PIL issues in the Bombay High Court. That's the third thing. And lastly, I would just say that there are issues, there are several issues which we can work on, and I think I came to know about the group only when I saw sort of on the thing regarding privatization of a hospital, of a BMC hospital, on which many of you had raised some issues. And that is an issue which we have, a lot of us have been working on, health issues, where we find that most of the hospitals which were originally public hospitals or BMC hospitals are now being converted into private hospitals. And when you convert hospitals into private hospitals, then the benefits which the poor require, you cannot get, because you have to pay substantial amount of fees or whatever the expenses for the treatment. So therefore we have to really fight for preserving our public hospitals. And it's not just the public hospitals, we also need to ensure that proper facilities are there. अगर हम BMC hospital देखेंगे या कोई और दूसरा public hospital, you find that most of the basic facilities are not there. Even X-ray machines are not there, or specialized machines or medications for, say, cancer patients or for any serious illnesses are not there. So we must ensure that government spends X number of funds for maintaining public hospitals in their proper condition and with all the available facilities, etc. So hospital is an issue which I think all citizens are concerned with, and we need to work on that if people are working on these issues. The second part is there are workers who are working in different factories and concerns where the ESI hospitals are supposed to, they are supposed to get benefits for the under ESI. That is also not being done. In fact, if we see, most of these ESI hospitals have closed down, and those same hospitals are now being, I know for example in Parel, where very good ESI hospital is now being converted into a private hospital, and a lot of expenses, infrastructure has been done, but it will be handed over to a private concern. So these are some of the issues that we need. As far as our city is concerned, we also need to ensure that public facilities are available, whether it's a park or a garden or schools for children, close nearby schools. These are all important facets of a city to be run in a proper fashion. And if we do not have proper schools, or the schools that are set up is only for private institutions, but the public schools are, I don't know if anyone is working on the Right to Education Act here, but now the government has introduced a new GR was issued about a month back, which said that schools which were supposed to give admission to disadvantaged children, there is an RT Act which says that if a child belongs to SC/ST or is a economically disadvantaged student, then 25% of the admissions that are given in a private school should go towards such children. So the school is supposed to give free education to such children, which is about 25% of the total admission. Now this notification has been issued which says that it is no longer private. Unaided schools are no longer required to take in such disadvantaged children. So this is a very important issue on which people have been working on, and we are planning, we have filed a petition challenging that notification. So, I mean, this can go on and on. I will just conclude here that this is just a beginning session. I hope I didn't bore all of you, and I hope we can collaborate this thing. As I said, we are part of UCL also, which takes up all the civil liberties organized. Chandni was here, and any other help or anything that you need, we will be only too happy to help. Thank you.
Madam, how government has money for beautification projects or big MTHL projects, not for BMC schools,
Yeah.
public schools?
Yeah, correct.
Right? Madam, lower जजच्या अगेन्स्ट करप्शन केल्या म्हणून कंप्लेंट फाईल केली हायकोर्ट चीफ जजला. हायकोर्ट चीफ जजने त्या पर्सनला बोलवलं की तुम्ही म्हणता की करप्शन केलेलं आहे, तुम्ही प्रूव्ह करा म्हणून. प्रूव्ह तर तसं करू शकत नाही, तुम्ही म्हणाल तसं खरी गोष्ट. पण देन आफ्टर 3 मंथ्सच्या त्याच्यानंतर 3 मंथ्सने त्या जजला त्याने हे केलं की तुम्ही एक तर रिझाईन करा, नाहीतर आम्ही तुम्हाला काढून टाकतो. जर काढून टाकलं तर मध्ये गव्हर्नमेंट फॅसिलिटीज त्यांना भेटत नाही. तर त्या जजने रिझाईन केलं आफ्टर 3 या मॅटरच्या नंतर आफ्टर 3 मंथ्स. आणि त्या जजचा दादरला सादर डॉक्टरच्या समोर जो मोठा टॉवर उभा आहे, त्या टॉवर मध्ये 7.5 करोडचा फ्लॅट आहे. 7.5 करोडचा फ्लॅट आहे. आणि तो पर्सन ते ऍडव्होकेट आता प्रॅक्टिसिंग करतात. आणि 7.5 करोडचा सादर डॉक्टरच्या समोर हायर टॉवर मध्ये 7.5 करोडचा फ्लॅट आहे. पूर्ण डॉक्युमेंट माझ्याकडे. पण जेव्हा माझं म्हणणं एवढंच आहे, माझं म्हणणं काय आहे की जेव्हा त्या पर्सनने हायकोर्टला कंप्लेंट केली, हायकोर्ट चीफ जजला, किंवा हे करप्टेड आहे, तेव्हा त्यांनी त्याला बोललं तुम्ही प्रूव्ह करा म्हणून. आणि देन आफ्टर तुम्ही 3 मंथ्स बरोबर 3 मंथ्स अगोदर त्या जजला तुम्ही म्हणता की एक तर तुम्ही रिझाईन करा, नाही तर आम्ही तुम्हाला काढून टाकतो. काढून टाकले की तुम्हाला गव्हर्नमेंट फॅसिलिटी नाही भेटला, त्यांनी रिझाईन केला.
ह्याच्यात कुठेतरी सोल्युशन गव्हर्नमेंटने काढला पाहिजे ना, किंवा कोर्टाने काढला पाहिजे. त्या जजचा तिथे 7.5 करोडचा फ्लॅट आहे, कुठून आला त्याच्याकडे पैसा एवढा?
मॅडम
जजला 30,000 रुपये त्यावेळेला पगार नव्हता, त्याचा माईन स्टेशनच्या समोर 3.5 करोडचा फ्लॅट आहे. कुठून आला पैसा तुमच्याकडे? करप्शन पूर्ण 101% करप्टेड आहे.
Madam, judges are never punished, they are only transferred or they resign. Why is this so? You should punish them. How? We are punished. Government servants are never punished.
The money goes right to the top.
For investigating the disproportionate assets of judges and all that. Of course, they have a big salary, that's okay. But that disproportionate assets they have. What's the way to go about? Like he raised the point of having a multi-crore rupees flat in a posh area and all those things.
So there was a case against one judge of the Supreme Court, Ramaswamy, who had disproportionate assets. Not only he had like Persian carpets which are worth lakhs of rupees, he had huge flats, he had all kinds of facilities. People then raised this issue in Parliament, but nothing happened. Nothing happened. So,
Judges Protection Act is there, Madam,
no,
1985.
because of the impeachment thing, that if you want to impeach a judge for whatever reason, either it's corruption or for any other reason, the impeachment itself is very difficult. It has to pass the whole entire Parliament, both lower and upper house. It has to pass there with majority, which is very difficult.
Not possible. What happened in Calcutta? Calcutta High Court.
Yeah.
That is why they get a kavach, they get a protection.
Yeah.
It's like a kavach.
But the only way is for people to come out and openly then
Yes,
that's the only
that's
way.
what.
They take protection under the Veeraswamy judgment. What about yours and my kavach? We don't have any
Yeah,
kavach.
cannot road.
Yeah, see, I mean, while she was
No,
saying
dog
it,
is also paid.
Correct.
while she was replying to this, it occurred to me that she said that the Ramaswamy case it landed up in Parliament, but then they didn't impeach him, right? What does that all this point towards? It points towards our bad public representatives.
Yeah.
Somewhere or the other, we don't choose honest people. When an honest party comes forward, please support them, please choose. And second thing is, whichever are existing, hammer them to improve or go out of the seat. All these things have to be done. We have to interact with our vote. First thing is, of course, vote for a good person without any, selfish considerations. That's one thing. Second thing is, vote for honest people and tell them. I mean, that reminds me. I have to take your opinion on this. That a rule had come about this Supreme Court order. This none of the above came. Nota. All right. But in that, it fell short of saying that if a certain booth or constituency says that more than 20% or more than a certain percentage says that we don't like these candidates and votes on nota, then in that case, can the election get scrapped, or perhaps it doesn't have any meaning?
No, it doesn't have any meaning.
Doesn't have any meaning, yeah.
Fine. But I believe ADR, who had filed this case, if I'm not mistaken, isn't it?
ADR.
ADR had filed this case where they had demanded from the judge that a certain percentage be kept where if the voters beyond this percent, if they vote for nota, then in that case the elections be scrapped. Those 10 or 15 candidates will not be permitted to stand for elections for another 5 years. Now, perhaps they are demanded it. I've heard but it didn't pass. That's okay. Judges did not think it worthwhile, maybe.
No, Gaurav, that would amount to legislation by court. That is why the judge didn't get involved in it.
Achha, okay.
Understand that.
Fine. Yeah, there might be a reason for it.
A judge cannot pass a law. Judge only interprets the law.
Yeah, that's true.
Yeah, so that is the reason.
That's the reason it did not pass. Okay. Though they have demanded, they did not pass because of that.
So you are telling us to vote for honest and good party.
Correct.
I vote for him and he changes his party.
Yeah, I was trying
All my effort.
I know that can happen. That's a bad thing that happens.
Then all my effort.
Right. Now lots of horse trading has occurred. I'm aware. Twisting of hands by ED
Now
and
only one
everything.
party, no BJP.
Now only one is one.
Now only one party.
Because somewhere or the other,
All my effort of
people
going,
are
standing
there.
in line, going there, voting, waiting for that honest man. He becomes
I agree. That point.
But madam, we do not choose our candidates. The party chooses the candidate. We only stamp on the candidates. That is voting. So there is no right to us to choose the candidate. So what should we do for that?
Sir, I'm just trying to understand.
Representation of people at bogus.
We are educated people. How many of us are willing for our children to enter politics?
Representation of
That
people
comes
at
later.
bogus.
That comes later.
We are not allowing our children to enter politics.
We have not taught our children the preamble of the constitution.
Right, right.
Teach them the preamble first.
Right.
Teach them the preamble.
Yeah, you're right.
On the spot they will read.
No.
Police people take oath.
Teach. How many children, how many of our children know the preamble?
I'll tell you one thing.
All right.
Be a honor.
Every government officer has an oath.
Our children. You are talking about
Then
children.
all right. Here Priyanka.
But constitution is not taught in the schools.
How many of us?
That's the point.
Madam,
And
constitution,
children
sir, one minute,
to
sir,
speak
constitution
up.
should be taught in the schools.
Yes.
You understand?
Law should be
To
taught in the
speak up.
schools.
Yes, that is very important.
You know, what you say, question the authorities, rather than take everything lying down and, here we are, okay, paisa khila ke aage badho. No, sir, here we should, inculcate in that, set an example for them, that speak up, read newspapers, be aware of what's going on, and ensure that you bring about the change in whatever way you want.
So do we question our teachers in the classroom? Do we question our bosses in the office? No, you'll be removed out of the class. You'll be failed in the school colleges. Show me how many students are questioning the college school. So teachers don't
I can
teach.
understand.
So all are taking
Elsewhere,
tuitions.
elsewhere they can raise their voices. Elsewhere they can. Tree chopping occurs. Can't they question? Can't they speak up? Littering happens. Do they question? So wherever possible.
Government, the judges talk after they retire. Before they retire, they don't talk.
But if your question, you're put behind bars.
God in God.
What do you want to say, sir?
Challenge begins at home.
Sir, if your question, you're put behind bars.
Sir, if you want to say, stand back, say.
No, I just want to know what is an honest party and honest candidate.
Correct.
I just want to be educated.
That's up to you. How honest you are.
So
you get to
basically, I choose amongst the lesser evil, right?
Yeah.
So it's not honest, the lesser evil.
Right.
Yeah.
Right.
You have a opportunity today.
Yeah.
In these times,
The lesser evil join the bigger evil.
You have no choice.
he has a classic example of a joint commissioner.
Madam, I need your help in this. There is a PI and there is a bill which is filed on the 9th of August against the Joint Municipal Commissioner, Mr. Ranjit Thapane. Now, this gentleman is a great person. He is going to retire on 31st of March. And when I started tweeting last week, there are many people from BMC said, please don't add any more tweets because he's going to retire on 31st and he's not going to get his additional benefits. So I said, आज का मेरा benefit का क्या होगा? Because I'm writing this because he's running a company called as VMA Enterprise, VMA Properties LLP. Okay, and this is based out of Pune, and the authorized share capital is 40 crores. So you can understand what the net worth would be. His wife Meera Ranjit Thapane and Vaibhav Ranjit Thapane, which is his son, are both directors of this firm. Currently, what ready information I have is he's constructing a 104 apartment tower in Pune. There is a bill filed by a gentleman, Rusha, against the state of Maharashtra, and the rest of them are there. How do we prosecute this man?
But the case is going on. So,
It's going.
through the case now, what else? In the case.
I want to fight.
Yeah, become an intervener.
Yeah. Because see, you yourself are saying that he is going to retire on 31st.
Yes. I'm not saying he's a service.
No, whatever. So the question is that already a PIL is there. So I think that if there's no point filing a fresh one, particularly now if he's going to resign. In that PIL, maybe you talk to the petitioner and give him some more information that he might not have. You have some more additional information. Then you talk to them and see if you can either give them the information or become parties in it by intervening. You can do that, but you have to do it fast before the 31st. Otherwise, there's
No, but what is the other remedy?
Other remedy?
We know that the bill is filed.
Huh.
What is the other remedy for this? I want him to be arrested tomorrow.
How can you do that?
So I'm asking.
Melvin, you have to get the documents, make a case out of it, a criminal case, file try filing the FIR, you'll have to go through the whole process.
Yeah.
Unfortunately, there is no
Quick
midway
remedy.
pass.
Quick remedy.
Others will run away like Malay. Come on.
No, that's right. That our system is such.
Yes.
See what happens, Melvin. I'll be very honest with you. Half the people here, sitting here itself, ask questions. But how many will go out and take a stand? How many will go out and take a stand? Nobody. I give you examples. I mean, we say what we teach our children or what our children know. Children will only know what you teach them. Neighbor is not going to come and teach them, no?
Tomorrow I am filing a 150 for one.
Come, I told you.
Yeah, we are doing that at Megwadi police station.
Correct, sir. I'm doing it.
Volunteer with the senior officer.
मुख्य चीज इस पे ये हो रही है नहीं मुख्य चीज ये है कि कोई कमेंट्स देने को तैयार नहीं हो रहा है कमेंट्स देना है ना हमें ये कोर्ट कचहरी तो हो रहा है ना इसका तो कमेंट्स देकर के कम से कम इसको बैंड तो बजाओ आप लोग सबके सब चुपचाप बैठे हैं एक कमेंट्स तो दो ना इसके ऊपर कि किस तरीके से एक ऑफिसर कर रहा है उसने 30 करोड़ का अपना वो बना लिया ये कर लिया हम लोग चुपचाप बैठे हैं अरे जैसे जज ने 30,000 जज वो ले रहा है और 7.5 करोड़ का वो बना लिया हम लोग कमेंट्स तो दे ही नहीं रहे ना कमेंट्स दो ना आप लोग ग्रुप में बैठे हो एक कमेंट्स कोई नहीं दे रहा ट्वीट नहीं कर रहा कुछ नहीं कर रहा और फिर कहते हैं कि क्या बोलते हैं वो कोर्ट कचहरी तो यही हो रहा है ना साहब इस पे ऊपर एक लोग अपनी रिस्पॉन्सिबिलिटी तो लेना
Today nothing better than social media.
अपनी खुद की जिम्मेदारी तो लेना सबके सब
In our group we have almost 35 odd people. And how many tweets? We have been continuously, Gaurav Bhai, myself, Clarence, all the other Reggie, everybody has been tweeting, retweeting. We are saying please retweet, it will take you 2 seconds. But why aren't you tweeting? The penetration that happens because of the retweet. You can't imagine. When I go to BMC office in HC Ward, I'll tell you, all of them are taking the mobile. They are not reading magic show. They are only reading the tweets.
Correct. But nobody wants to do because मेरा घर पे रह रहा है.
इसके लिए बजा रहा हूँ.
मेरा नौकरी जाएगा.
तो बोला मेरी नौकरी जाएगी. मैं बोला तेरी छोकरी भी जानी चाहिए. तेरी बात कर रहा है तू. मेरा तू तो सबकी बजा रहा है. मैं अकेला तो हूँ जो तेरी बजा सकता हूँ.
सनी जी बराबर बोले सनी जी बोले 2 मिनट का सिर्फ वीडियो में कमेंट्स दो ना इस एक चीज पे कमेंट्स तो दो आप लोग सब लोग दे सकते हैं ये बैंड बच जाएगा उसका हम लोग सिर्फ 10 लोग हैं ना पूरे देश में 10 लोग एसएमएस भेजते हैं और कैसा एसएमएस भेजते हैं वो भी समझ लीजिए हम लोग लिखते हैं कि पंजाब में बाप और बेटे द्वारा बेटी का बलात्कार जायज ऐसा वर्ड हम भेजते हैं कैसे भेजते हैं पूरे प्रूफ के साथ भेजते हैं अरे यहाँ पर है आप लोग इतने सब लोग अरे एक भेजो तो सही वहां हमने हिला दिया पूरे पंजाब को और आप लोग यहाँ पर इसको नहीं हिला पा रहे बड़ी आसानी से हम हिला देते हैं हिला करके उनका बैंड बजा देते हैं
कमलाकर जी 40,000 करोड़ 4 लाख करोड़ मेंढी दिखती नहीं किसी को
नहीं दिख रही
क्या बोल आपने सर हमारा 40,000 करोड़ की बात करें 4 लाख करोड़ की बात करें यहाँ कोई साला ट्वीट ही नहीं करता क्या मतलब
आई एम टेलिंग यू ना अपने किसी से पॉकेट मारा तो भी आदमी चुप बैठता है बोलता पब्लिक मारेगा so this is what it is if you don't stand up for your right don't expect them to stand up for your right understand that
जो लोग
and I am talking out of experience okay I tried to lead 3,000 people I was forced to lead in fact and when the time came I was left holding the baby by myself
we go to the ward officer myself and register so what is saying what is your concern तेरा बाप का क्या जाते why are you questioning me yaar I am a citizen I have full authority you are a public servant I am paying your salary
because he is used to other people coming and saying sahib bada kaam karo
exactly sir
yes
that and they don't like questioning
exactly
what problem we go to the police you go to BMC SRA Mara we've been there Kamlakar sir but then तुम्ही येऊ नका why only him
अरे yesterday
Kamlakar sir येऊ नका तुमचं काम मी करून देते
yesterday माडा
काय करणार
मेलविन
काय काम करणार सर विचारा
yesterday माडा the officer is saying अरे आप इनको क्यों लेके आया इधर आपका काम मैं करके देता ना ask him
नहीं आपका फोटो भी नहीं जरूरत है राव बोला तो खो गया और आम करेगा
नहीं अभी अपन ने आयोग का फोटो लगाकर वायरल किया है ना कोई अपने इसमें ग्रुप में किसी ने नहीं ट्वीट किया कुछ भी नहीं किया मगर हम तो डरे नहीं हमारे ऊपर कहते हमारे आदमी को धमकी दिया हमने उसका बैंड बजाया पूरा सब कुछ किया। अरे डरने की जरूरत नहीं, पूरे प्रूफ है, सब कुछ है। यही रास्ता है हमारे पास, यही रास्ता है। देखिए 2 महीने का बच्चा है, वो क्या चिल्लाएगा? वो हाई कोर्ट जानता है, वो सुप्रीम कोर्ट जानता है, वो फर्स्ट अपील जानता है? नहीं जानता, वो चिल्लाना जानता है। तो आप लोग चिल्ला सकते हो, प्रूफ है, सब कुछ है, सिर्फ चिल्लाना शुरू करो, पूरा फोटो लगाओ, वायरल करो, कार्टून बनाओ। अरे हिम्मत करो ना।
हमने एक कार्टून बनाया था फॉर माय आयो शिवनारायण जी, तो पुलिस वाला बोलता है तुम कार्टून कैसे बना सकते हो? मैं बोला क्यों, पेन है मेरे पास। मैं तुम्हारा पेन नहीं लिया हूँ ना, मैं तुम्हारा कागज लिया हूँ, तो कार्टून क्यों नहीं बना सकते? तुम्हारा भी बनाऊंगा, सबको भेज दूंगा। तुम गलत एक काम करोगे, तुम्हारा भी यही बात। हम लोग बैंड बजाने के लिए आए हो, आपको जो करना है करो। पुलिस स्टेशन में जाके मुंह पे बोल के आना एक बड़ी बात है।
100%।
नवनीत साहब, ये जो ट्वीट होते हैं ना, ये रीपोस्ट या रीट्वीट और लाइक के अलावा अगर कमेंट भी करे और एक क्रिटिकल मास होने के बाद वो ट्रेंडिंग होता है ट्विटर पे, और जब ट्रेंडिंग होता है ना तो बहुत मुश्किल होता है उन लोगों को।
सही है,
तब तकलीफ होता है।
यस।
आज इसी प्रेशर की वजह से डायरेक्टली इनके मैटर में लिखा है फायर ब्रिगेड ने कि हमने कोई एनओसी नहीं दी। अरे सीधे सीधे, और वही फायर ब्रिगेड ने 2-3 बार लिखा है कि नहीं यहाँ कोई प्रॉब्लम नहीं है।
सर
सीधे सीधे पेपर प्रूफ आ रहा है इसी प्रेशर की वजह से, और कोई प्रेशर नहीं है।
ये ऑलरेडी प्रूव हो चुका है। बीजेपी ने डिमांड किया है कि ट्विटर में एक एम्प्लॉय गवर्नमेंट की तरफ से होना चाहिए। ये न्यूज में, ये मेरे बनाया हुआ न्यूज नहीं है। यहाँ तक कि मेरे जो ट्विटर हैंडल है हर 2 दिन सस्पेंड होता है, हर 2 दिन। फिर मुझे ये एनिमल ये डिसाइड करो, फिर अनलॉक करना पड़ता है। और यहाँ तक के पूछते हैं कि भाई ये टेलीफोन नंबर तुम्हारे है कि नहीं, प्रूव करो।
Judge Shahid, you know, I went to represent this lady. She can't speak English, she can't speak Hindi properly. IAS officer, he's trying to threaten me there. I told him, boss, चालू करूँ क्या मैं? I said, is it a law that you're talking about? Saying, I am the boss in this room. I said, but I am the boss outside the room. Your word only goes here because the chamchas are here. I told that vice president of MADA, close down MADA. Builder has written to me that I don't need MADA's OC. I can occupy the building. And I told him, I said, boss, IAS officer, na? I said, my reputation, go search. Collector of Goa is sitting in Andaman and Nicobar Islands.
I have a small suggestion.
I don't talk, I do.
Sir,
People only come and ask questions.
You know, recently I had gone to the executive engineer. He says this. He's telling me this is illegal, but I can make it legal. I have approved it. I told him, hey God, how you can approve it? मैं बोला कागज पे दिखता है सीधा सीधा. There is no proposal. तुम बोल रहे हैं, मैं बोला उसका शादी हो गया. वो 9 महीने के बाद भी बोलता है मेरे पास बच्चे नहीं. हाँ नहीं. तू बोल रहा है उसके 3 बच्चे. बोले कहाँ से आए? Have you parented the children? मैं बोला तो मजाक बना के रखा है. We are going there in the first appeal, mind you. So when I questioned him, he was wondering कि ये बेवकूफ आदमी क्या बोल रहे हैं. मैं बोल रहा हूँ मैं बराबर हिंदी बोल रहा हूँ. अगर तुमको समझ में आती है तो ठीक है, नहीं तो रिजाइन होके घर पे बैठ. तुम्हारी कोई औकात नहीं.
Sir, I have a small suggestion. All these people, Gaurav sir, this is for you. All these people who have got so much of them, have a form a committee like that, so that people, you know, outside people who have no access to anything. I'm telling you, so many people are suffering. Every day I get 10 calls minimum. Okay, now please, all those people can be directed. They can direct all the people correctly. Because we would not know everything. Please have a committee, and I would request all of you to input, please. Because all of you are very that's what
जिम्मेदारी लीजिए. एक कमेंट गोरा जी ने एक वीडियो डाला कि भाई एक कोई भी मैटर डाला, इस मैटर पर सब लोग अपना अपना कमेंट 2 मिनट का वीडियो दीजिए. ऐसा एक जिम्मेदारी ले लेंगे ना, आराम से पूरे काम होने लगेंगे. आराम से. अरे 10 लोग करना शुरू करेंगे, इमीडिएट रिजल्ट आएंगे.
you have to take the
It's time to wind up.
I will make one group law.
Address all these things or commit to whatever suggestions given by Sami, you and everyone. A strong point has been made by Shivnarayan just now. When an issue is raised of injustice, wrong things going on, illegality, people don't join in. People don't put in their efforts. I can understand, but then so much selfishness is also not good on the part of activists. Outsiders can be selfish, can मेरे को क्या है उसमें, मेरा तो problem solve हो रहा है ना, या मैं तो उसका लड़ रहा हूँ ना, अभी मुझे क्या है? Let's not keep that narrow-minded view of this. Others' problem you try to solve, others will come to you. You understand? So let's all, you know what to say, join in this thing of raising objections, supporting others who are taking up issues. He's boldly taking up issues with police and the authorities. Everyone is in their own way. When such things come forward with us, to us, support it. All you have to do is, you know, endorse his petition or retweet, or as Sandeep said, retweet with comment. So these are the things where, and once you start, you know, if many people are not on Twitter over here, I can understand. Learn Twitter. It's very simple. Okay, a person who is on Twitter, got that tip. Learn those minimum things: how to retweet, how to retweet with comment, how to, you know, understand what a handle is, Twitter handle, and the hashtag, the magic of hashtag. That's what he was referring to when he said trending. It trends, hashtag trends easily. So what's the meaning of trending of a hashtag? These are the small things about Twitter. We have kept 2 sessions on Twitter already. People, you hadn't got involved by that fact. Earlier we have kept the beginning of petition group. So these are the things. So get involved, do that. Okay, second thing is Sunny had said that videographing, you know. Prepare a video clip and everyone's opinion is taken on that, on one issue. Do that. Sunny ji, if anyone is good at, you know, videographing and can move about, you know, for taking everyone's opinion on an issue, okay, wonderful. We can put it on YouTube on our petition group website and make it viral. Everyone else can in their own way, and we too will do that. So please look into that matter.
But you can ensure it is within 2 minutes. You can't have more than 2 minutes. Yeah.
Perfectly fine.
Yeah.
Yes, even 10-15 seconds opinion, everyone gives, 10 people give. It will be wonderful.
Yeah.
Third thing is, Vasant Sena ji, you had said that others are affected, they can be guided, right? Now, for that we have already have a petition, a group, our own WhatsApp group, in which we have experts like Rao Saab, RTI, Mr. Sanjay Purare, and there are many such experts. There are some Uday Shankarji on CHS. So there are already experts on the group, some lawyers also. So these are the people who guide people on it. But you all need to conform to certain conditions to be on the website. Okay, on this, petition on this group. Once you do that, because here it is, you know, you scratch my back, I will scratch yours. That policy is there. We need to support others to make support. Let's understand. If you feel that मेरा CHS का problem ठीक होगा ना, तब तक मेरे को I need guidance, fine. But then you have to come forward for other CHS problems, or other police problems, or other MADA problems, or other redevelopment problems. So that attitude, if you keep, you can come on the group. Here experts guide you and be a part of it. Take this movement forward, because there are several ways you can. Money is not required. Don't worry. That's the wrong impression. कि पैसा, no पैसा नहीं भरने का. दूसरे के support में आइए, वो काफी पैसे से double triple ज़्यादा, वो ज़्यादा अच्छा है. So keep in mind. All right. So these are my replies to, you know, all concerns we expressed just now. Now, of course, we need to wind up. Gayatri ji. So thank you everyone, all the participants over here who have patiently sat through these 3-4 hours over here. Hope the food was good today. And as his also, like for Twitter, the issue that raised about Ranjit Dhakne, joint municipal commissioner, it's a high level, let's understand this, just next to municipal commissioner. When such a person, he points out as a corrupt person, what are we doing? He is raising his voice. There are very few people who are retweeting. Please don't do that. Please come forward. Maybe he can start emailing. You know, support that. I endorse it. It's a shame. There's his Twitter handle is there. Never mind. But then you can. Iqbal Chagla, Iqbal Chahal, Twitter handle is there. My BMC Twitter handle is there. Hammer it, support it. CM is there. Devendra Phadke, Home Minister is there. Okay, Chief Secretary is not there. Never mind. Whichever authorities Twitter handle is there, do that. Retweet that. Okay. So thank you very much. People are moving forward. Please sit down. Please, you can always speak later. Rao Saab.
प्लीज सब लोग बैठ जाइए, बाद में बात कर सकते हैं।
गारंटीड एक्शन चाहिए, मोदी बोल रहे हैं ना हर मिनट।
हाँ, मोदी की गारंटी, सो ऑफ कोर्स हमारी भी ये होनी चाहिए। सो लेट्स सी, okay. Another thing is there are several budding law students over here have been made to understand, or lawyers already over there. Request you all to kindly pull in your expertise. We want you all to be with us in this movement to make our country a better place to live in. So kindly join in. We are thankful to Gayatri ji for giving us the time today, Obey ji for her leisure time. Sunday is one day where she gets the time to relax at home. Otherwise, she's continuously in the office with her subordinates and preparing for the next pension and next Frederick or whatever, So we are thankful to you. And yes, people who wish to join. Some people expressed opinion that expressed wish that they wish to join they want to be a part of the petition group. This group of activists. You all have my number. Please send a message that I wish to join. I'll send you the link to it, the conditions and the link to it. Please fill up the form on that. It's an automatic system. So fill up on that. You'll be made a member of the group. Alright. And in future, as you all know, we keep having such seminars, educative seminars by legal experts, by lawyers, environmentalists, whatever. That is for empowering us, for making us better citizens, making us better activists. So, if you all feel that certain things need to be spoken, certain topics we need to keep seminars upon, or there are certain experts who can give us better guidance over here, please revert back to us. Please let us know that if we can have this seminar, this expert, that expert. We'll try our best to hold such seminars in a very good place, most probably over here. Alright? So, thank you so much for everyone for coming over here. Most of all, thank you Gayatri ji for coming over here. Yes, thank you. Jai Hind, Jai Maharashtra.